I know where it's from. Yes, I do. It was an old, it wasn't actually him. I can't use it, right? You got a copyright. Senate Judiciary is now in session. Good to see you all. We're going to start with Senator Alschlitzer on, I said the name wrong, I apologize. It took me a long time to get Perkins Quoker right, so it's going to take a little time. SB 244, good to see you, Senator. Welcome to Judiciary.
Nice to be back. Thank you very much, Mr. Chair and honorable committee members. For the record, my name is Deborah Altschuler. I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Rye, and Stratham. I am here to introduce Senate Bill 244 relative to false public alarms. In the beginning of this current school year, CNN published an article about the fallout from active shooter hoaxes, beginning with a school in Arkansas and multiple schools in Florida. You have a packet passed out to you, and it is in your packet. It has a picture on the front. Students, teachers, and parents were all traumatized by these experiences. Then it was our turn. Less than 2 months ago, we had 10 schools that experienced false alarms of an active shooter. Students in Exeter, Concord, Claremont, Dover, Franklin, Laconia, Lebanon, Littleton, Portsmouth, and Whitefield experienced the terror of wondering, are we next? Teachers and administrators' hearts stopped beating for a moment when they realized they had to transition out of their teaching mode to protecting lives mode. After the chaotic response to the mass murder of children and teachers in Uvalde, Texas, parents across the nation started looking for information about how their local law enforcement departments planned to respond to a similar situation in their communities. I've attached an article from my district about how we are preparing for the day it happens here. It is the Seacoast Online article entitled, "We Don't Wait, Seacoast Police Train for Active Shooter Threats." There have already been 50 mass shootings in 2023. And gun violence has now been established as the #1 cause of death for American children. There's an attachment here called Child and Teen Firearm Mortality in the US and Peer Countries in your packet. The threat of being a victim of a mass shooting is very real. We know it, and our students know it. Education Week tracks school shootings, and according to their data, there have been 6 school shootings this year that resulted in injuries or deaths. There have been 150 such school shootings since 2018. There were 51 school shootings with injuries or deaths, the most in a single year since Education Week began tracking incidents in 2018. There were 35 in 2021, 10 in 2020, and 24 each in 2019 and 2018. The threat is real, we know it, and our kids know it. When a report of an active shooter comes in, response has to be as if it is real. And we are now responding to deal with this direct threat. This appropriate response doesn't come without cost. In addition to causing stress and fear for the public, hoax threats also cost taxpayers a lot of money in police response, mental health counseling, and lost classroom time. Senate Bill 244 seeks to acknowledge the seriousness of making an intentional false report by including it as a Class B felony. A prosecution and conviction of a Class B felony could face a potential incarceration of 3.5 years to a maximum sentence of 7 years, and these charges can also result in fines of $4,000 and up to 5 years of probation. Intentional false reports of active shooters do real harm and should be treated with the seriousness they deserve. I strongly urge the committee to recommend Senate Bill 244 ought to pass and hold people who willfully traumatize our communities and exhaust our resources to be held accountable. Thank you.
Thank you for your testimony. Do we have any questions? Okay. Just a general question.
Yes,
Just,
please.
and I certainly, this would be a terrible thing, happened anywhere. No one should do this and they should be punished. My fear is, Rick could probably tell us, when can you be tried as an adult? If a 16-year-old, 17-year-old, they're probably not going to know the penalty. And could they be tried as an adult for this? Okay.
The court can certify juveniles as an adult under criteria in
Is that
statute.
commonly done for 16, 17-year-olds, or is that a risk?
Not for things that don't involve a lot of real
So my
violence.
only fear is an idiot kid, as a lot of people are at 16, 17, 15, don't realize the severity of what they're doing. Certainly an adult, I'm fine with them going away for 3 years. I'm just a little concerned with that 15, 16, 17-year-old doing this and a felony conviction if they were tried as an adult. It's just something I just thought of. It may not even be a problem.
Mr. Chair?
Yes, go ahead. Thank you. Senator Whitley.
Thank you, Mr. Chair. And just to follow up, Senator Altshuler, my understanding, and I haven't practiced in this area for many years, but I did practice and represented individuals in the juvenile justice system. And from what I understand, it is very, very, very rare for a child to be certified as an adult. And as Attorney Lehman said, it typically would involve, actual extreme violence. So is that similar to what you understand?
Yes, I mean, it is my experience and understanding through work with juvenile justice that getting certified as an adult for the purpose of criminal charges is rare and a very arduous process to go through. But yeah,
Thank
thanks.
you both. Senator Abbas.
Thank you, Mr. Chairman, and thank you for taking my question. If someone were to make a false claim of a present active shooter that
Yes,
involving, let's say, a school, would that fall under, currently, would that person be charged under RSA 644:1 as the misdemeanor, or is there a separate statute they're being prosecuted under? I mean, like, would that conduct today fall under this? Because I understand.
I don't think it's enumerated under our misdemeanor claims. It's a false alarm. But what I'm seeking to do with 244 is enumerate this specific kind of alarm because of the culture that has come up and the real threat. I gave one of you my copy of the bill in the packets that went out, so I don't have it right in front of me.
And my read of it is,
Yeah,
it says, say, under the current law, if you make a false claim by regarding a fire, explosion, or other catastrophic incident or an emergency, you can make an argument that that would fall in the emergency, but it would only be a misdemeanor. So potentially Class A or Class B. And is it the purpose of this to pull out the specific threat of the presence of an active shooter to make it a Class B felony?
one more time, it's the purpose, I'm with you, I'm sorry, I just didn't hear
Is the
you.
intent of this
Thank
to,
you.
presuming that the false report of an active shooter would fall under the emergency clause provision, which would make it this discretion of it being an A or a B misdemeanor, is the purpose of this is to pull that narrow circumstance and make that specific instance a Class B felony?
Yes, indeed. That is exactly the purpose and
Thank
the
you.
point for a specific type of threat. Thank you.
Seeing no other questions, thank you for your testimony.
And thank you, whoever just brought this up. I appreciate that. Thank you.
Does anyone wish to speak that didn't sign in on 244? Seeing none, thank you.
Good afternoon. The record, Senator Darrell Labus. I represent District 22, communities of Pelham, Salem, Exton, and Plastow, and the prime sponsor of Senate Bill 248. There's a couple of drafts of this floated around last term, so whether it was the House or the Senate, so it may seem familiar. But ultimately, what the goal of this bill is, and I understand there's been some significant changes in some of the bail laws over the last couple of years. This is not an attempt to roll back what we've done to change the bail laws, but it's narrowly focusing on some of the egregious circumstances we've heard as a byproduct of the bail reform that has passed. So it's kind of trying to level the playing field, at least reach a middle ground on some of the concerns. So specifically what would happen is if someone is arrested for or in charge for any of there's 12 crimes that are listed on page 1, lines 24 to 31, that goes on to the next page. All of those crimes are either a violent crime where the victim of the crime is a person. So we're not talking about breaking and entering, or if someone were to smash my car window. We're not talking about that. We're talking where the violence act is the victim is a person, or it's a sex crime where the victim is a child. That's what we're talking about. We're also talking about sexual assault claims, stuff like that, domestic violence charges. That's what we're focused on. In those scenarios, rather than go before a bail commissioner, that person would be held and brought before a judge for their arraignment. The current practice is, more often than not, if you get arrested and you have a bail commissioner, if you are awarded bail, that naturally you would then waive your arraignment. So this will mean you have to go before a judge, and at that point in time, it will be at the discretion of the state to decide if they want to seek to have you held awaiting your trial. They would have to meet the burden by clear and convincing evidence that the person poses a danger to themselves or to the public. In my opinion, unless you're dealing with some of the more serious charges, whether it's murder, if you're a first offender for, let's say, domestic violence, I think it's unlikely you would be held on this, especially at misdemeanor level. If you're a repeat offender, obviously the more it happens, the weaker your argument is that you don't pose a danger to someone else. So what this also does is we've heard some circumstances, and just pulling some out that happened. There's one person who was arrested for domestic violence. They got out they were released by a bail commissioner within a short period of time, about 1 to 2 hours. That person actually then broke into the victim's house and then sexually assaulted that person in front of the child. So we're talking about some of the extreme circumstances. Could this person still be released by the judge at the hearing in court? It's possible, but at the same time, we're talking less than a 24-hour window. So we're trying to really take some of the more egregious circumstances. I believe this is a good attempt to try to do that. There is a bill that we'll hear a little later today, a Senate bill, I believe it's 252. There was some communication with myself and some of my colleagues. It's actually the same bill. So I would ask that you support that bill as well. Remind me to sign in support of it. They're literally the same language. So if you combine those two bills, this would have a great amount of bipartisan support. And it's something that I think public safety is important. And we're really trying to just look at what some of the most egregious circumstances are and address those. And if there's any suggestions on any tweaks to make to this, the one comment that was raised to me earlier today was there was some question of whether that clear and convincing evidence standard would apply to the defense or to the state. The purpose of this bill is that the state would have to prove that. If there's any suggestion that language is not clear, I would have no objection to amending it to make it clearer that it's the state that has to meet that burden. And keep in mind, they have to also seek that. If they choose to not seek that or to pursue that, then it's what it is. They won't be held. So I'll answer any questions and be happy to discuss with anyone.
Thank you, Mr. Chair. Thanks for taking my question. This is a tough topic, right, that we've talked about for many years, since I've been in the Senate. How can we get to a place where both the public feels safe and, right, we're not incarcerating people who are potentially innocent, right? It's this balance, right? And both are worthy of significant consideration. So the way that I read this bill is that, looking at the current system, this bill will remove judicial discretion for certain alleged crimes, correct?
I don't believe so. What it would be doing, actually, in all honesty, I think it gives more judicial discretion because if you commit one of these or charge one of these 12 offenses, you have to go before a judge, not a bail commissioner. So the judge could still just as likely release the individual at the arraignment as opposed to the bail commissioner do it. We're not changing that standard, that if the state meets the burden by clear and convincing evidence, now they can already do that if they request a hearing to do that, but this is happening at the arraignment, and it really, this happens fast. If you get arrested, Monday night and you're brought in court on a Tuesday morning, if you're gonna meet that burden, if the state's gonna meet that burden, they're gonna have their information ready to go. Because I'm just pointing out, like, they're gonna have to meet that burden, and it has to be something where they have, I would say, solid evidence to meet that burden. So it's not necessarily gonna mean the judge has less discretion. It's not requiring the judge to make that, make the determination to be held, but they can actually do that.
So, I mean, I sort of disagree because we're looking at sort of automatic incarceration, right, for certain alleged offenses.
I don't believe it's automatic, because the state still has to meet the burden by clear and convincing evidence that you pose a danger to yourself or to someone else. And there are several circumstances under the law today that exist that would allow that to happen anyway. So all we're saying is at the arraignment stage, if the state chooses to seek that and meets that burden, they would be held. But also when it comes to issuing the bail, the person's being brought before a judge, not a bail commissioner. And just, again, these are violent offenses against a person or sex crimes against children. That's all we're dealing with here. Not necessarily every type of offense or prop breaking, entering. We're not dealing with that type of stuff.
Follow up?
Yep.
So maybe other people can sort of, address that also. So as we're sort of evaluating the best, way to proceed, I want to hear about the existing tool. So the existing law, and I don't practice in this area, full disclosure, I never have. But my understanding is that we do have tools currently in the law. Like, for example, the state can challenge release orders, right? Like, so say a person's going to be released, and we have heard these horrific stories, right? But the state does have the ability to challenge. Do you have any sense about how often that is used? And if it's not being used, why is it not being used?
I can't speak to how often, but I can tell you this. And when it comes to victims of violent crimes, I don't like to just look at how often does it happen, because if you can still prevent a victim being victimized more than once, I think that's a good policy. Now, one of the problems is that, again, if you go before a bail commissioner, and I'm not criticizing bail commissioners, there's nothing suggesting that they're applying the incorrect legal standard, but if you go before a bail commissioner and then granted bail, you're not even appearing in a courtroom yet, because it wouldn't, at that point, you're going to waive your arraignment anyway. So for the state to seek this, they would have to do it at a later hearing. It's just, you're way down the road at this point. And what I'm talking about is in between that, the person who committed domestic violence got out on bail by a bail commissioner that same night, and then the victim of their first offense was also the victim of their second offense. And it was an elevated offense. So really, we're looking at those limited circumstances where that happens and trying to really hopefully prevent that from happening in the future. This, I think, is a reasonable stopgap to prevent that from happening, without rolling back the whole system to what it was prior to the reform, I believe, in 2018.
Follow up? So thank you for that. So the state does have the ability. So if a release order is made, the state is required to, like, very promptly, if they disagree, to file that, right? To challenge the release, right?
To go through the exact procedure, I don't want to speak out of turn and mispresent it, but we can discuss it. I'm sure my colleague, Attorney Lehman, will be able to walk through that. But I can, when we have an executive session on this bill or the other one, I'll try to get that information for you. But my understanding is they could ask for it, but it's not quite the same argument if the person's not in court. So you're gonna have to schedule a hearing for an all. I guess the procedure doesn't line up. It's not analytical to have that if the person's already been released, and if they committed a subsequent offense at that point, the second crime's already been done as well. So.
Follow up? But they're not released, right, if it's challenged?
Well, and what I'm talking about is they're released by the bail commissioner, and now the person's been given bail, they never appeared in court, they waive their arraignment, and then commit a subsequent offense. before they ever appear in court. I'm trying to look at these crimes with they're violent offenses or sex crimes against children.
I totally understand that, but my question is like, if this is happening and we're hearing that it's happening, I don't understand why the state isn't immediately challenging those to prevent the release. That's my question, I guess.
I suppose if the procedure permits them to do it, they can, but the person's already been released and they've already had their bail granted them by a bail commissioner. And
They're
we're,
being released because the state isn't challenging it, right?
well, before the bail commissioner, they don't even have an opportunity. The state is not in there to actually challenge that.
But it's permitted under the law, right?
So
Why isn't the state there, I guess is the question.
So the bail commissioner, they're not there. That's not a formal hearing where a prosecutor is present to oppose that, to my understanding. Some of these hearings are in the middle of the night.
Thanks.
You can just help me. I'm probably far less knowledgeable than you on this, but maybe it'll help Senator Shanley. So my friend Eddie, big bail commissioner he's out at 2 and 3 in the morning, Friday and Saturday nights. So just help me walk. He makes determinations all the way up to murder, he tells me, and I don't know if he's correct on that. So you're charged with one of these 12 violent crimes right now. How many of them are at his discretion to let people out right now on a Friday or Saturday night? Are all of them? Does he have discretion on?
I believe the murder, only with the exception of murder, the rest of them, and it's not necessarily discretion. There is a burden you have to meet at that.
Yep.
But my point is, in these cases, we want the person held and brought into a courtroom. And there is some talk that when a person's in a courtroom, a lot of these cases can get resolved faster, if that's the case. And we come to a determination whether the person wants to enter a plea or not. And that actually could be beneficial sometimes, especially if you're dealing with cases that are in a circuit court level, perhaps not letting them go up to the Superior Court. We're talking some more limited circumstances, but there are some benefits of actually getting into a courtroom.
So my friend Ed let somebody out at 2 in the morning on Saturday. Is the problem that the prosecution's all at home and no one's on top of this, not murder, but a lower level, and then we're waiting till Tuesday? Is that the problem? Is that part of the problem? That potential innocent person is waiting till Tuesday and they don't get their day in court early enough? They don't have this hearing?
Well,
So-
but once the bail commissioner issues the bail, whether it's a Monday, Tuesday, or Saturday,
Yep.
once that happens, the common practice is the person then waives their arraignment. Because at that point, they've already gotten their bail. At an arraignment, if you enter your guilty plea or not guilty, if we're dealing with bail, it would be not guilty. And at that point, there's a bail hearing in the courtroom. If you've already been granted bail, that's why it's being waived. So they're not actually appearing in court. And you have several occasions where you have people charged with felony level violent offenses or sex crimes against children, where then that person's not ever appearing in court and they don't often show up at the next court date. So this is allowing to address those violent circumstances or those violent charges and address a public safety concern without rolling back the whole system. We're not talking about minor offenses here involving, drunk driving. We're not talking about possession charges involving drugs. We're not even talking about felony distribution charges and drug trafficking. We're talking about crimes where the actual person's a victim or the victim's a child of a sexual act.
Thanks, Senator. Any other questions? Seeing none, thank you for your testimony.
Thank you.
Chief Alan Eldenberg, come on down. Hi, Chief, how you doing today?
How are you?
Good. You enlighten me and help me understand more will be great.
Can you hear me okay?
Do you have your ready? You do. Good.
All right. Good afternoon. I'm Chief Aldenberg. I'm Chief of Police for the Manchester Police Department. I appear before you today in support of bail reform. In my testimony today, I hope to provide you with some insight into the following. Overall, crime may be down, but crime types that are significantly more harmful to the community are up. Types of reoffending while on bail are alarming. The inability to hold some offenders results in greater harm to the community through more victimization. There is now no deterrent effect of arrest for bail. Bail reform was passed without adequate pretrial services, so there is no oversight of offenders who do bail. Others will probably testify today that crime is actually down since bail reform began, and therefore there is no evidence that the changes to the law have made New Hampshire less safe. The fact is that, yes, overall crime might be down in New Hampshire. However, that is an oversimplification of what our communities are really experiencing. This is because different crimes cause different harms. A proper assessment includes detailed analysis of certain types of crimes to understand true changes in crime since bail reform began. I'll cite some statistics from Manchester so it gives you a perspective. Since bail reform began in Manchester, we have seen simple assaults increase by 6%. Theft from buildings increased by 145%. Theft from motor vehicles increased by 16%. Theft of motor vehicle parts and accessories like catalytic converters, like many of your communities are experiencing, has increased 38%. And credit card fraud has increased by 15%. As the chief of police of the largest city in this state, my number one priority is violent crime. And it's a key crime indicator we assess is gun crime relative to our violent crime. Since bail reform began, gun crime in Manchester is up 10%, and it was up 40% year over year for 2022. Gunfire incidents where a gun is actually being shot is up 18% since bail reform began. And it's up 21% year over year for 2022. If it's not for the relentless efforts of the men and women of the Manchester Police Department, we haven't seen, it could be worse. And we've been seeing success, and we've been able to reduce non-fatal shootings by about 40% in 2022. And that's due to the targeted enforcement of prolific gun offenders, as well as outreach to our youth within the community. It is no coincidence that these increases have occurred since bail reform began. The lack of ability to hold prolific offenders pending their trial increases reoffending and absolutely makes our communities less safe. Let me give you this. The type of reoffending we are seeing in Manchester is very alarming. From April to December of 2022, we documented over 700 arrests where the arrestee was out on bail for a prior offense. 700 arrests from April to December. And 700. They were out on bail for a prior offense. Their reoffenses included 9 were arrested for robbery, 9 were arrested for burglary, 32 were arrested for weapons offenses, and 18 were arrested for aggravated assault. And 1 was arrested for murder while out on bail. I feel it is important to provide you some examples to highlight the public safety concerns and to emphasize that we are talking about real victims, which often gets lost in this conversation. Many will probably testify to you today, and my guess is that some of them won't even mention or say the word victim. These are real victims. These are real people in our communities that are suffering due to some of these people and the crimes they're committing. I mentioned the homicide. That individual was charged with first-degree assault, criminal threatening, and falsifying physical evidence on July 10th of 2022. He was held on a preventative detention when arrested, but was converted to PR bail on 7/11 the following day. When he was, taken into consideration that during his July 10th arrest, he indicated that he had just arrived in New Hampshire from another state and he had no fixed address. And then less than 2 months later, I have an individual that is stabbed several times in the city of Manchester and is murdered by this individual. Completely avoidable. I had another stabbing. This individual was released on PR bail on June 27th of 22 after being charged with possession of a controlled drug. Released again on August 17th after being charged with 6 counts of possession of a controlled drug. His prior criminal record included felony convictions for reckless conduct, receiving stolen property, felon in possession of a dangerous weapon, felon in possession of a dangerous weapon. And then on 12/31 of 22, we respond to a large fight and where two people had been stabbed. And subsequently, that individual was taken into custody for 2 counts of first-degree assault, riot, falsifying physical evidence, and many other felonies. Another example. This individual was arrested 8 times by the Manchester Police Department since August of 2022. He was arrested in August for simple assault, arrested again on the 31st of August for simple assault, stalking, violation of bail, arrested again on September 13th for resisting arrest or detention, released on PR bail, arrested again on September 16th for falsifying physical evidence, possession of a controlled dart, violation of bail again. He was arrested again on September 28th for 1 count of stalking, violation of bail, again released on PR bail. Arrested on October 6th for 1 count of armed robbery, 1 count of felon in possession of a dangerous weapon, receiving stolen property, fraudulent use of a credit card, falsifying physical evidence. Bailed again, bailed by Superior Court again, arrested again on December 26th for theft of unauthorized taking, a Class B felony, released on $1,000 cash. And last night, finally, my officer took him back into custody for a capias out of Hillsborough County Superior Court. So you can imagine the frustration, not only by my community members, but by my officers as well. I just listed how many times we had to deal with one individual, and that's just one example. I could go on and on, ladies and gentlemen. Again, like I said, you're going to hear from others that what I just gave you is merely anecdotal, when actually that's reality. That's the reality that the men and women of my police department are living in every day, and it's greatly impacting my city, the city of Manchester, and quite frankly, the state as a whole. Our citizens deserve better. Our police officers deserve better. And frankly, the victim of crimes deserve much better than what we are giving them. I'm happy to take any questions that you may have.
Hi, Chief. I'm going to start with me because I probably need the most education on this. And I should be at a higher level, but I'm not. So right now on Saturday night, my friend Ed, who you probably know, he's out 3 times in the night letting people, making a judgment call. Evidently everything but murder. So all these other 11 violent crimes, he's going to decide, did the domestic violence, is it going to happen again? He has all these things he's weighing at 3 a.m. And so if he decides, he's going to lose his discretion, right, under this bill. It's all these 12 will now mandatorily have to wait till the judge, if it's a holiday weekend, can see the person on Tuesday morning, right?
Or Monday morning.
Or Monday morning if it's not a holiday.
Yep.
Okay, so these will be automatic. Okay, where I need to be. Thank you. Anyone else have any questions? No? Nope, we're all good. Thank you, Chief.
I appreciate your time, folks. Thank you
Thanks for your
listening.
help.
I has to go teach it too.
Okay. Bashir, come on down. We're putting you out of order because you're gonna go teach and we gotta educate people. But you're gonna teach us here, right?
The job you get paid for.
My name is Buzz Sure. I'm a professor of law at UNH School of Law. I'm also an elected police commissioner in Portsmouth. My testimony today is my own opinions. They do not reflect those of UNH Law, or the Portsmouth Police Department, or Police Commission. I appreciate Chief Oldenburg's testimony. I would point out a couple things in relation to his testimony. Number one, the example he gave of a person being arrested 8 different times. This bill, SB 248, would not have any effect on that circumstance, because those were all misdemeanors. None of them were on the list of crimes included in SB 248 for different treatment. Number two, he referred to an individual who was charged with first-degree assault and subsequently committed a murder after he was let out on bail. I've investigated at great lengths that circumstance, and it is a circumstance of a abject failure of prosecutors. That's why that happened. It's not because of the bail system. The individual was a homeless person. He was, and I've read the transcripts of the arraignment on the first degree assault and the transcripts of the arraignment on subsequent misdemeanors that were committed before the murder was alleged to have been committed. What happened was he's a homeless person. A group of other homeless people surrounded him, and he pulled out a knife and was swinging his knife like that. The police were called. Nobody was hurt. He was arrested with some difficulty arresting him, taken to jail, and saw a judge the next day. He was charged with attempted first-degree assault. So this was not a first-degree assault where somebody was injured in any way. It was the waving of the knife was arguably, depending on one's perspective, a self-defense maneuver. Nobody was hurt. He had a hearing in front of a judge, Judge Delker, the next morning. The prosecutor argued for either preventive detention or bail with conditions, which was not a powerful argument for him being held. I think the prosecutor recognized that it was not the strongest attempted first-degree assault charge, and the defense lawyer spoke, and the judge found that, in his opinion, given the very triable nature of the attempted first-degree assault, he was going to grant him PR bail, but he was going to put significant conditions on it, and that's why he was released. Fast forward to early August, the individual was arrested, I believe, in Nashua for refusing to leave, for a misdemeanor refusing to leave McDonald's. That he was not arraigned on that. He was summoned on that. He was then arrested yet again in later August for disorderly conduct, I believe it was, and 2 counts of resisting arrest. An arraignment was held on that set of misdemeanor charges and the early August misdemeanor charges in Nashua District Court. I've read the transcript of that hearing. The prosecutor never mentioned the attempted first-degree assault, that he was out on bail. A big failure on the part of that prosecutor. What happens is the county attorney, the assistant county attorney on the first-degree assault never files a motion to revoke his bail on the first-degree assault. And because of the failure of the Nashua prosecutor, because of the failure of the assistant county attorney, then the alleged homicide occurs a little later in September. So that example that the chief offered is not an example of the failure of the bail statute. It's an example of the failure of the prosecutors to do their job. Now, that could be because they're too busy, because they have way too many cases, they're not communicating with each other. There's a whole bunch of reasons for that. But I think it's unfair to target that circumstance as an example of the failure of the bail statute. Because it didn't fail in that circumstance, the prosecutors did. Just a couple of quick things to address issues that already come up. It is under Senator Abbas's proposal. It is automatic that if a person is charged with one of these, I think there are 12 crimes, one of these 12 crimes, it's automatic that they are held in jail until they see the judge. So in that sense, it's automatic. And that can be as much as 4 days if they're arrested on a Friday evening and Monday's a holiday. And others will testify as to the significance of being held in jail as little as 3 days can have on a person's life and on what happens. Finally, I've circulated an investigation that I did with a student of mine named Travis Bennett, a second-year law student. What we did is, in an effort, well, let me back up a second. One of the problems we've had the last 4 or 5 years is we haven't had data. We've had stories on both sides of the issue about the way things are, the horrors of bail reform, that it's a cause of all sorts of crime. On the other hand, claims that it in fact is not the case, that crime rates are going down. I decided last summer that we needed at least to make an effort to collect data so we know what's actually going on in the system. And what I've circulated among you, I will talk about 4 quick facts, so to speak. We looked at, we got a number of case numbers, over several thousand case numbers from a 91A request to the Judicial Council. We then took those case numbers and requested of the court system, and you can do this by phone, here's the case number, we would like the case summary sheet, and they email you the case summary sheet. So we started collecting case summary sheets, and then we started coding the case summary sheets as to what was happening. The effort was to figure out how many people, what's the story in terms of people being released on bail and subsequently being arrested for another crime, as best we can tell from actual data in the court records. We've looked at 508 cases. This study is continuing. And of those 508, there are only 4 circumstances in which an individual was released on bail, and then later in the case, a motion to revoke bail for violation of bail conditions was filed. That means this includes a little over about 330 felonies in Manchester Superior Court and about 170 or more misdemeanors in Manchester District Court. That information, 4 out of 508, 0.79%, tells us one of 2 things. The fact that people are committing being arrested for additional crimes after they've been bailed isn't happening as much as it seems. Or 2, it's happening more than this data reflects, but prosecutors are making the choice not to file a motion to revoke bail, which is certainly part of what's going on. Point 1. Point 2, frighteningly, out of that 508 cases, just about 37% of them, the charges were subsequently dismissed, or null pros, which is the prosecutor getting rid of the charge rather than the judge dismissing the charge. 38% were dismissed, which means if you increase the number of people being held pretrial on bail, you're inevitably increasing the number of people who later will be found not to have committed those crimes. The charges will be dismissed for one reason or another. So we will be over-incarcerating people, and we will be over-incarcerating innocent people if we increase the number of people being incarcerated. Finally, most of the people, the huge majority of people in the 508 cases we looked at, are not getting jail sentences or prison sentences. They're getting suspended sentences. Again, if we increase the number of people being incarcerated, we are incarcerating people who wouldn't otherwise, even if they were convicted, serve jail sentences. So this is a real concern. And finally, of the 334 cases in Hillsborough County Superior Court North that we looked at, over almost 72% of them were drug-related charges. They were not violent crimes. So these drug charges are charges that have been bogging down the criminal system in New Hampshire ever since the opioid crisis developed. They are important crimes, but other than the defendants themselves, who are victims of the crimes that they are committing, they are not. They are as a relative matter, they are victimless crimes. You will hear from others about how expensive this bill would be to the court system in a time when the court system is struggling with the repeal of felonies first. You will hear from others about crime statistics since bail reform was passed. But I offer to you that the problem is not the statute. The problem is the administration of the statute. And in the examples I've given, the problem is prosecutors who, because they're overworked, because they have too many cases, or because they have bad communication between them and police departments or other prosecutors' offices, they're not doing what the current bail statute allows them to do. More than willing to take questions.
Just a quick question. So you heard the chief before, he had 700 arrests of people who were out on bail for. His numbers seem totally opposite your numbers.
No, they're not. Okay. The question is 700 arrests for, it's one thing to be arrested for a minor shoplifting and then subsequently to be arrested for disorderly conduct. That's while out on bail being arrested for another crime. I'm not sure anyone on this committee or in this room would necessarily say that person needs to go to jail because they're arrested while out on bail. So there's all sorts of different crimes in that group of 700. In that group of 700, somebody made a decision not to bring a motion to revoke bail under the original charge. If that's what's not happening in this system, the system already allows for a district court prosecutor or a felony prosecutor in Superior Court to bring a motion to revoke bail when somebody's arrested for a crime after they're out on bail. It's a condition of every bail order, be it personal recognizance or cash bail in this state. So we need to look at why those cases aren't being brought forward for a motion to revoke bail. So it's either that's the problem or the problem is they're not worth bring forward because the
Remember your 38%? You said you had a number on 38%.
37% were people who were arrested and charged. Subsequently, their charges were completely dismissed.
Could be because they had a good lawyer like you. Might not mean that they're.
Well, hopefully they had a better lawyer.
There could be
than
other
me.
factors. There might be other variables.
Yeah, but if we start holding more of those people, those variables could be.
Well, it doesn't mean they didn't do the crime. They just were found not guilty. So they might have charged correctly and the prosecution just couldn't convict.
The huge majority of the ones in our study, they weren't found not guilty. The cases were dismissed or the prosecutor null-prossed the cases. The prosecutor themselves dropped it. We don't want to be holding people whose cases are going to get dismissed.
Senator Abbas has a question for you.
Thank you, Mr. Chairman. Thank you for taking my question. But isn't all this bill is doing is if you commit one of these or charge one of these 12 offenses, ultimately you're going to be held and brought before a judge for your bail hearing as opposed to a bail commissioner. Now, the other side, whether the state wants to file something or not, or seek you to be held a waiting trial, that all exists in the law already. So isn't this just simply you commit one of these 12 offenses, that's what your charge is, you're being brought before a judge for an arraignment, and that's...
That's only part of the story. The other part of the story is it's very much more likely that the judge, seeing that they're charged with one of these crimes, when they see them, will continue to hold them, given the nature of the crime. You can't capture that with a statistic, but given the nature of given that these crimes are would be listed in the bail statute, it's very likely that the judge will be strongly predisposed to find clear and convincing evidence.
Thank you, Mr. Chairman. But wouldn't the prosecutor still have to meet that burden of proof by clear and convincing evidence? So if this prosecutor is not prepared or overworked or whatever it is, they're going to show up at that hearing unprepared, probably with 20 to 30 case files with them that they all got from the night before. And you can run this might not actually solve the problem in its entirety. So I'm just saying that could still happen. This means that you're just going before a judge, right? That's all it's doing.
At that initial hearing, the New Hampshire Supreme Court has said that the prosecutor can just stand up and read from a document. They don't have to call witnesses. So it's not, and if the defense wants to call witnesses, they get to request another hearing. And so it's not really a fair hearing. It's a one-sided hearing where the prosecutor stands up and says that.
And follow up, and I understand that, but that's existing law today, correct?
Well, the existing law is the first time a bail is set is with a bail commissioner. They're not held necessarily. Sometimes they are, sometimes they're not.
Let me do a follow-up. My point is, if the court does decide to hold someone, or if the bail commission decides to not grant someone's bail, there's already a procedure in place that defendant can challenge that and have a hearing where they can even have testimony.
Yes, by that time, they've been in jail for 5 or 6 days.
My apologies. It's my understanding under the existing law today, if a person is denied bail, whether it's by a judge or a bail commissioner, they can then challenge that at a hearing where they can have testimony presented on their behalf.
Which will occur 5 to 6 days after they're held.
Yes, and that's something that the defendant would,
And we're just increasing the number of cases where that will happen.
under the presumption that more people will be held by a judge than a bail commissioner.
No, we're increasing the fact that someone will be held on these 12 charges will be held without any bail until they see the judge. And then when they see the judge, if they want an actual hearing with witnesses, it's going to be another 2 to 3 days.
But that's presuming the judge actually denies them bail, correct? I'm just trying to make sure the procedure is being presented.
Yes, yes. And as I said before, it's going to be more likely, given these list of 12 crimes, that they're going to deny it in the first instance.
But wouldn't that require the prosecutor to meet the burden of proof? By
Yes.
clear and convincing evidence that they pose a danger to themselves or to someone else, someone in the public?
Yes.
Thank you.
So as a matter of policy, we're weighing public safety. You're siding more in the liberty interest of the accused. Would that be a?
No, and we're weighing the cost to the system. And you'll hear from others about that. That this is an expensive solution to a problem that may not be as bad as some have characterized it to be.
Thank you, Mr. Shear. Go teach.
Thank you.
Thank you. Chief Brofowski. Hi, Chief. Good to see you today.
Yes, thank you. It's great to see you as well. And thank you, members of the committee, for hearing my testimony. Before I start, For the record, my name is John Brofowski. I'm the Chief of Police in Bedford, New Hampshire. And I'm currently the president of the New Hampshire Association of Chiefs of Police, representing more than 160 chiefs throughout the Granite State, all of whom are in solid support for this Senate bill as well as its companion bill that represents minor surgical but yet common sense changes to the bail statutes so necessary to preserve public safety in the Granite State. Just to start off, you may have read recently that in 2022, the Granite State suffered more homicides than it's had since 2002. So a significant increase in the most homicides that we've seen in over 20 years. The particular nature of this common sense change is not going to result in mass incarceration. The surgical change and the common sense approach to bail reform with a very limited number of significant violent crime that affects real victims, as prior testimony from Chief Oldenburg so rightly indicated, simply requires that the decision for whether or not an individual who's been charged with one of these violent crimes rests before the judge, not a bail commissioner at 2 o'clock in the morning in a booking room. where there's insufficient information that's available to the bail commissioner to be able to make a learned decision on the most violent crimes that affect the citizens of the granted state. So this particular change simply results in those people charged with the most violent crime in the state of New Hampshire to appear before the judge. Secondly, in connection with the prior testimony that you heard regarding statistics, the statistics cited indicated that those numbers reflected decisions made by the judge. This particular bill focuses primarily on the decisions made by bail commissioners. There's been a replete number of cases in which individuals who were arrested for one of these or more of these violent crimes were released by bail commissioners. The one case that I continue to go back to because it is emblematic of the problem that we face here is a individual from Boston who was a convicted felon, a prohibited possessor, comes to the city of Manchester, shoots up the city of Manchester, thankfully didn't kill anybody, but nevertheless is charged with that crime and is released on his own recognizance. I would offer that you ask any of your constituents, in what world does that make any common sense? To release someone who shot up the streets of Manchester or Nashua or Claremont or Franklin or other places where these things have happened, and then these individuals are released. So the chiefs are adamantly in support of a necessary change that affects a very, very limited number of individuals charged, again, with only the most serious crimes. When we talk about charges and statistics, it's important to consider all the moving parts, if you will, when we start looking at court cases. When we consider cases that are null processed or not processed, as was indicated by previous testimony, oftentimes, in my experience, and I have every single minimus that is ever sent to me by the county attorney in Hillsborough County saved. So I look at each and every one. The vast majority of those NPs represent global plea arrangements in which another charge on another case was either combined with these charges and a decision was made by a prosecutor to drop that charge in consideration of a global plea on another charge that may result in a better outcome for in the interest of public safety. The number of hearings that we're talking about, again, there's a member of this committee that in prior testimony in a House bill a year or so ago calculated, being a member of the defense bar, calculated the expected number of hearings before the court and calculated that those numbers of hearings were well within the capacity of the judiciary to withstand the number of hearings that were proposed. Revoking charges and indicating that that these charges are likely to result in no prosecution, again, needs to be balanced against the full information and data. In ending, members of the committee, this is truly about the victims of crime. This is truly about victimology and whether or not it results in one less homicide in the state of New Hampshire. I would argue that if it saves one person's life, then it's worthy of consideration and worthy of passing in the state. Thank you.
Thank you very much for your testimony, Chief. Are there any questions? Okay. Seeing none, thank you very much.
Thank you, Madam Chair.
The here will see, Chief, Chief Oliver, you are, okay. So Captain, Trevor?
Trevor, yes.
Thank you.
Good afternoon, Chairman Carson and members of the committee. My name is Brian Treffery. I'm the Detective Bureau Commander in Nashua, New Hampshire. I'm here to testify in favor of this bill. I'm not going to reiterate the statements made by Chief Brunfronsky and Chief Aldenberg. I agree with them. What I would like to say is, I've been a police officer in the state for 20 years. I've seen a number of changes made in the legislature, both for good and bad. And like with a lot of problem solving, sometimes things go too far in one direction. And we are now in a time where we need to correct some of those changes. When bail reform was initially legislated in 2018, there were some needed changes. There were a lot of shortcomings within the system, and there was people who were incarcerated that shouldn't have been. Unfortunately, we're now seeing the unintended consequences of providing too much leniency to those who violate the law, leniency to people who don't deserve leniency. I feel that this step would be a good step in the right direction to correct that. One thing that I would like to do is, cite an example of an individual who would have been held overnight and seen a judge in the morning earlier in my career. But subsequent to 2018, he was released and then reoffended that same morning. So in November of 2021, we arrested a subject. His name was Jency Diaz. His case has been completely adjudicated, so I will speak freely about it. Shortly after midnight, he was arrested for assaulting his girlfriend. She was a young woman, a little over than 20 years old. She had an infant child in the residence with her. He committed a domestic assault against her after he arrived home intoxicated and confronted her for cheating on him, which she wasn't. He was a possessive, manipulating man, and ultimately he committed a misdemeanor level domestic assault on her. We responded. We saw evidence of the crime that he committed to the injuries that the female had on her person. We attempted to place Mr. Diaz into custody. He resisted arrest. He was ultimately arrested. In addition to the assault, he damaged property within the residence, and he was taken off to jail. Like I said, earlier in my career, Mr. Diaz would have been seeing a judge the following morning for what transpired. However, he was released on $200 cash, and within 4 hours, he returned to the residence in violation of his bail conditions, mind you, conditions that were set by the bail commissioner, prohibiting from returning to the residence or having contact with the victim. He disregarded those, just like he disregarded the common decency to not assault somebody. And he returned to the residence. He made entry into the residence. He located the victim. He violently and brutally beat her, to include pulling out clumps of her hair and whipping her with a belt. He then sexually assaulted her before fleeing the residence. We apprehended him a short time later. He pled guilty, and he's now serving a state prison sentence. One thing that we heard earlier today with a gentleman that testified in opposition to the bill is the expense and the cost of what is laid out here. Well, I ask you, what cost did the victim in this case pay by Mr. Diaz not being held for several hours to see a judge so a judge could weigh the gravity of what he committed and whether or not he is in fact a danger to the community and to this young woman specifically? It was mentioned earlier, the bail commissioner doesn't have all the facts at 2 a.m. An adequately prepared prosecutor and a defense attorney can make a convincing argument one way or another to a judge the following morning, and the judge, with all their legal experience, can make an informed decision as to whether or not this person needs to be held or whether they can be released back out into society. And that's what this bill affords us, and that's why I think it's important to support it. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Captain, I do have a question. You've mentioned the bail commissioners a few times, and I know that the bail commissioners play a very vital part in this whole process. What is your opinion? Do you think that the bail commissioners have the necessary knowledge in order to make a good decision about whether or not someone deserves bail, or do they even have the ability to make that decision that bail is automatically given?
So what I would say is the bail commissioner is an agent of the court. And each court system in the state is slightly different, and different judges have different perspectives and opinions on things. And they, my understanding is they dole out kind of guardrails for their bail commissioners. We have the option when we look at what criminal offenses are, right? There's the ones that are all the way over here and the ones that are all the way here. Nobody's going to argue that somebody that committed the crime of murder shouldn't be held. And I'm also not going to argue that somebody that stole a $5 loaf of bread at the supermarket should be held without bail. Just like I'm not talking about people who are affected by substance abuse disorder should be held for personal use amounts of narcotics. And that's not what we're here to talk about. We're here to talk about actual crimes with actual victims. And, I'm sorry, Madam Chair, I went off on a little tangent there, but we have the ability to request preventative detention. Now, the metric for requesting preventative detention is a set of facts that we relay to the bail commissioner, and they are able to take the information that we provide them and then make a decision that's in alignment with the directions they've got from their respective judges. So for the worst of the worst, we're going to request preventative detention. And 9 times out of 10, the bail commissioner is going to agree, and he's going to err on the side of caution and hold that person preventatively. If we can't make an argument to satisfy him, even though we feel, the state feels, the arresting agency feels that this person should be held, the bail commissioner is going to release that person with bail. Whether it's personal recognizance, whether it's a cash bail, it's really irrelevant because he's getting put back out on the streets.
Okay, thank you. Are there any further questions? Seeing none, thank you very much.
Thank you.
Okay, the chair will call Richard Head. Good afternoon, Mr.
Good
Head.
afternoon. Thank you, Madam Chair. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We have no position on the policies behind this bill, some of which I'm going to talk about, I agree and admit would be better before Senate Finance. But it also, there is an ask at the end of it as it relates to the policy and the bill itself. And what I want to talk about is the impact on the court system and how various changes are impacting the court system and what the court system is trying to address as we speak and what we're seeking to address through the budget. This morning at 10, the Chief Justice gave a presentation to Division 1 regarding something called a weighted case study that was conducted last year in the court system, and it evaluated essentially judicial and clerical needs throughout the court system. And what I'm focusing on today is the circuit court, because what we're talking about primarily in this bill is an impact on the circuit court. And that's especially true in light of the fact that the repeal of felonies first will become effective on January 1, so that all felonies that are currently being heard in Superior Court will be moving into circuit court for purposes of bail arraignment and probable cause. When I'm talking about circuit court, I'm talking about district division where the criminal cases are heard, family division, and probate division. And all 3 of those divisions are part of the circuit court, and they're all heard by the same judges. So the same judges are hearing the criminal, the family, and everything in between. We get, on average, about 127,000 cases filed in the circuit court every year. And we have 42 full-time judges and 6 part-time judges. And so what does that mean in terms of what they're dealing with, and then ultimately what the impact is of a bill like this? What we do is we break down all of the caseload and all the judge time into judge days. Essentially, the judge has a day that the judge can be available and can hear cases. And if we break down the total number of judges and the number of days, we have a total of, or session days, I guess, a total of 249 session days. So, and that's assuming judges don't take vacations or holidays, or vacations at least. It goes down to about 220 if you assume some number of vacations, but let's go with the 249 session days. If you add that and you combine into how much time does each case type take within the circuit court, you need about 16,000 session days within the court system if you're going to do those and do those fully. If you take the number of judges we have in the 249 session days available per judge, we have within the system currently a little over 10,000 session days available. 16,000 is what you need to meet the full caseload that's coming through the court system. On top of that, if you just look at the cases that have a statutory deadline built into them, so they have to be heard within a certain number of days, taking aside the constitutional deadlines, just straight up statutory deadlines, about 5,000 session days are consumed in that. And we have available with the number of judges about 10,000. So half of those are being taken up by statutory deadlines. Landlord, tenant, you have to hear them with, I think, 14 days. And then, we have a domestic violence petition that comes in. Those have to be heard immediately. You have various things you build into the system. You're taking up about half of the session days on those deadlines. Add on top of that criminal, which has its constitutional speedy trial deadlines and other deadlines. You have a tremendous burden being put within the system. The system is full as we currently have it. Felonies First will move about 10,000 criminal cases from some Superior Court to Circuit Court come January 1. And that now has to get absorbed into the system. The budget request is presented that will be presented by the Chief Justice asks for an increase in judges. The other aspect of this is also what is happening when we talk about court staff and court clerks, because we're talking about bail. The burden is on the judges in terms of hearing time, but if you see the time that the court is spending in a bail hearing, you have to take that and multiply it several times to evaluate sort of what is the time that the court staff have to take on. It's a great deal of paperwork and other things that go into making sure when it arrives on the judge's desk, it's happening on time and the paperwork's in front of that judge. So what we're talking about is a system that is highly loaded with the current caseload. If we were to proceed with this bill, we estimate that it's just on the misdemeanor side, so the stuff that already goes to circuit court, it's about 2,500 additional bail hearings. And then if you add on top of that, whatever may be, you have the defendant has rights of appeal of those bail decisions. There could be subsequent hearings, but let's assume with the one. And then another, once Felonies First is repealed, 700 that come over into the circuit court side of things. So about another 3,500 hearings that get put into this system. Felonies First is a January 1st trigger day. We have that load coming in. The request that we would have if this bill is to go forward is that there be some consideration of moving the effective date so that we're not doing everything on January 1 come next year. That there be some ability to absorb, assuming the Chief Justice's budget requests are implemented, to absorb new judges, new staff, Felonies First, and reform of bail, all happening essentially at the same time. The administrative work that is going in now to implement the repeal of Felonies First is a daily occurrence. It is a significant burden on the administrative staff just setting it up to go into place. These burdens are significant, and to the extent there's any relief if these bills are going forward, this or any of the others, that the committee consider a modification of the effective date to allow essentially some sequencing to occur.
I'm going to interrupt you for a second, Mr.
Absolutely.
Head, because you keep talking about felonies first, and we're talking about here, bail for defendants. So can we keep our comments to this bill? I know that there's other bills dealing with felonies first, and there's going to be the fiscal requests and everything, but we're looking at the policy. So if we can keep focused on the policy and not all the other things, that would, I think, be very helpful for the members.
Sure. So thank you. Thank you for that. And my only reason for bringing up the felony first repeal was, as it relates to the policy, we have a confluence of several things occurring at the same time that are essentially at January 1. So if we have, new staff, new judges, new cases coming into the circuit court because of the repeal of felonies first, and bail reform bringing new bail hearings into the circuit court on January 1, it's just an additional load that needs to get absorbed into the system, in a system that's already overloaded. So it gets into the policy request of asking the committee to consider whether in this bill or any of these bills, a push out of the effective date to allow essentially sequencing of the stresses that are being built into the circuit court.
Okay, thank you very much. Are there questions from the committee? Mr. Head, I've got a few questions. We had previous testimony that basically said each court is different and they handle bail commissioners differently. Do you think that this piece of legislation is going to standardize the conditions under which bail will be given on any defendant coming upon arrest?
So it would bring those decisions to judges, and each judge would obviously be making their own individual bail decisions. But whether part of the answer is I don't know in terms of how that will impact the bail decision-making process. They're all sort of talk to each other, and the judges do have regular meetings, so they do communicate with one another, and they do have an overall administrative judge, and they're responsible, they get involved in the same training, which includes these types of decisions. But at the end of the day, each decision is an individual judge's decision based on the facts and circumstances.
Well, I think, Mr. Head, and I'm not going to get into an argument with you, but I do believe that the statute here is very clear, and it says a person who is charged with homicide, first-degree assault, second-degree assault, domestic violence, aggravated felonious sexual assault, kidnapping, stalking, trafficking, robbery, possession, manufacture, and distribution of child sexual abuse images, computer pornography, and child exploitation, and I left out references to the various RSAs,
Yep.
shall not be brought before a bail commissioner and shall upon arrest be detained pending arraignment before the court. I think that's very, very clear, and it says these offenses will not go in front of a bail commissioner.
I may have misunderstood your question. That's absolutely true.
Okay,
Yeah.
I want to make sure, because what we're basically doing is saying, look, the judge can run his courtroom, but in this circumstances, when you have individuals that have been accused of committing these types of violent crimes, they have to go in front of a judge. They're not going to go in front of a bail commissioner. They must be seen in front of a judge, and I believe there's a time frame. Shall occur no later than 24 hours after the arrest, Saturdays, Sundays, and legal holidays excluded, no later than 36 hours. It's very, very clear. So I find myself a little confused with your testimony, because as I read the proposed statute, it's very clear. And it will be standardizing those bail conditions across every court.
So I apologize, I misunderstood your question. Absolutely, by this bill, anything that falls within that list of crimes would go before a judge, not a bail commissioner. and never go before a bail commissioner. I apologize if I misunderstood the question.
My second question has to do with the effective date. You've given us a few reasons why this should be extended beyond 2024. And I'm referring to the testimony that I heard from Captain Truffry. I'm sorry if I'm messing up. I'm not really good with names. And gave us an instance where someone committed a domestic assault, was let out on bail, went back to the victim and horribly beat her and sexually assaulted her. I mean, I can't see creating that kind of a situation again, where someone is let out on bail and they go back to the victim and heaven forbid they kill that victim. Because we've done this on January 1st, 2024, and the court is asking us to extend it because they have other things that they have to do. To me, I'm sorry, I don't buy that argument. In fact, I think this probably should be upon passage to directly address safety concerns in our communities. Because what I'm seeing here is a revolving door. People getting arrested. The police are out there doing their jobs. They're catching the bad guys and girls. But the problem is they bring them in and they're let out and they go right back out and they do the same thing or something different. That's not in the best interest of public safety. And that's something that we really and truly need to stop. So I would really ask you to go back to the court and have a discussion about changing that effective date to upon passage for public safety.
And
thank you.
So thank you for the question. What we're involved with is triage in the circuit court. And whenever we add things that have statutory deadlines, constitutional deadlines, what we're talking about here are things that are happening immediately. So every time you're doing that, you're causing something else not to happen within the system. So everybody who is coming in with a divorce case, a parenting case, their civil cases, their trust and estate cases, these are, I get the issue of public safety. I'm not questioning that in the slightest. And what I am saying, and it is simply raised as a policy consideration for this committee, is that every time we insert something that has to get done, something else is going to get pushed within the system. And what all I'm suggesting is we are pushing a lot into the system on one day, on January 1st. If there is spacing to consider, that is great. If, as a policy consideration, you say, no, these are sufficiently high in priority that's okay, my only job here is to explain that consequence, not to say, anything different. Ultimately, it is a policy decision, which is why I'm talking about the sort of impact on the system that this committee will make, and ultimately the legislative body. And I get, that's a difficult balance, and I'm not questioning the difficulty of that balance in the slightest. I just am here to provide that information that, for individuals, their parenting cases, their divorce cases, their probate cases are extremely important, and delay is problematic for those people also. And I'm not questioning the public safety aspect of what you said, though.
Thank you. Thank you, Mr. Head. Are there any further questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Frank Knack. Good afternoon, Mr. Knack.
Thank you so much for the opportunity to testify today. My name is Frank Knack. I'm the policy director with the ACLU of New Hampshire, here in opposition to SB 248. So there's a couple of, you'll see in the packets I handed out, there's a couple of things that I was hoping to talk through with y'all today. One, and I know Professor Scherer talked about this a little bit in his testimony, is the fact, and the chief talked about that, we don't want to talk about victims. We absolutely do want to talk about victims here. And we are not trying to diminish the harm that is happening in communities. Well, from our perspective, as Professor Scherer talked about, we have multiple tools under the current statute that are not being utilized. And so when we hear about the case in Nashua, for example, when we hear about the case in Manchester, what we heard were just the outcomes, the harms that were created. What we didn't hear was how step A failed, how step B failed, how step C failed in current statute. And instead of completely undoing the current statute where where people can go before the bail commissioner and have the opportunity for release or not be released, we are going to mandatorily hold people based on an unsubstantiated allegation that, again, if you refer back to Professor Scherer's testimony, when he actually looked at some data, 36% of those cases were later dismissed or null prossed. And so you're talking about removing judicial discretion, mandatorily holding people for up to 4 or 5 days with the huge collateral harms that can have for, if someone is a primary caregiver, for example, of an elderly parent or a child, and that person is then removed from their house. If they're removed from their job, some people work shift jobs. If they're out for a day, they lose their job. So these have tremendous collateral harms. And all we're talking about is ensuring that we maintain a system where we have individualized determinations based off the factors in current law. Is that person a danger? Is that person a flight risk? If so, they can be detained under current law. That's the way it should be. That's the way the Constitution sets it up to be. If they're not a danger, or if they're not a flight risk, they should be released. But it's based off of those individualized facts in that case, and not one-size-fits-all approach what this bill currently brings to the committee. Also want to talk about data. We've heard over and over again that since bail reform went into effect, crime has skyrocketed in New Hampshire. I know the chief talked about some cherry-picked examples from Manchester of how in certain aspects crime may have gone up. Overall, in New Hampshire, crime is down 18% for Group A crimes. That's all violent offenses and almost all other offenses since bail reform went into effect. That's using Department of State data between 2018 and 2021, which is the most recent data available. In Manchester, Group A crimes are down 13% during that same period. So the notion that bail reform has somehow made our communities less safe is not backed by data. I'm not sitting here and saying that bail reform is the reason that crime has decreased. That would be disingenuous on my part, but the notion that somehow bail reform has made our communities less safe is not supported by any evidence. It's also, we've heard a lot about public safety and the notion that we need to pass this law to protect public safety. Again, I think it's really important to look at data and research around bail. There's been tremendous amount of research around bail and the carceral harms of holding people in pretrial detention for the very reasons I talked about before in terms of the collateral harms, losing jobs, losing access to family, etc. More recently, there was a case by Arnold, a study by Arnold, supported by Arnold Ventures, which is a major national funder of criminal justice research and advocacy, where they looked at 1.5 million people released, held in Kentucky jails between, I think it was 2009 and 2018. And what they found was actually, it changed their thinking a little bit. Before, they used to think, 3 days was the magic number. If you kept someone incarcerated for 3 days pre-trial, the net public safety harm to the communities in terms of likelihood of recidivism increased. What they found with this newer research is that holding someone for any time undermines public safety in the community overall. We're not saying that no one should be held, but we're saying that having these blanket holds on whole categories of people without individualized determinations is problematic and will actually likely harm the public safety in our communities. And finally, we've heard a lot about the fact that, the problem is bail commissioners. Under this legislation, all this legislation fundamentally does is it doesn't make sure that everyone is held indefinitely pre-trial. It just makes sure they're held for up to 4 or 5 days until they get before a judge. And the whole thing is about holding people before a judge. Well, if the issue is making sure that we have people before a judge, then we should think about there's legislation in the other body right now, HB 46, that would replace bail commissioners with magistrate judges and ensure that everyone gets before a judge immediately. And what the beauty of that bill does is it ensures that no one is held unnecessarily, that everyone gets before a judge. So if the concern really is about making sure that everyone's before a judge, under that legislation, everyone will get before a judge right away and no one will be unnecessarily held. It's the best of both worlds. Happy to answer any questions. Thank you very much.
Thank you very much for your testimony this afternoon, Mr. Knack. Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair, and thank you for taking my question. I'm looking at the written testimony you provided, and it says this legislation raises serious constitutional concerns, and it discusses that the person can be detained, without bail pending their trial if there's a basis of dangerousness, and it must be proven by clear and convincing evidence. Do you believe that the Senate Bill 248 as written satisfies that constitutional issue or not?
I think there's concerns because it is, at the first instance, removing the opportunity to have that. They're automatically going to be held for up to 5 or 6 days under this bill. It's removing judicial discretion on the front end, removing their opportunity to get before bail commissioners. So if you look at the language, sorry, I have too many papers in front of me.
So just to clarify, if a person's being held and brought before a judge as opposed to a bail commissioner, that raises a constitutional concern? Because I know for first-degree murder, a person's not going to be brought before a bail commissioner. Is that constitutional concern for someone charged with first-degree murder do you believe that person should be brought before a bail commissioner?
I know that's been in the code and there hasn't been, I'd have to get back to you on that specific case. But our concern is that under the draft is written, sorry, here it is. So if you are alleged to have, if there's an allegation that you committed one of the 13 offenses, you quote, shall not be brought before a bail commissioner and shall, upon arrest, be detained pending arraignment before the court, which shall occur no later than 48 hours, but it excludes Saturdays, Sundays, and legal holidays. And so there is some potential concern there. I'd be happy to get back to you with more specific response to the constitutional question in this case.
Thank you. And it also, this legislation flips innocent until proven guilty. Isn't that the trial standard for it being innocent to proven? That's talking about the trial standard for conviction, correct?
So what, and I think, it'd be great, I can just quote the late Chief Justice Rehnquist here when he said, in our society, liberty is the norm and detention prior to trial or without trial is the carefully limited exception. And so I think that's what we're concerned about here is you are creating a blanket, regardless, it's not individualized, it is blanket by offense type holds on people under this proposal. And that is extremely problematic from our perspective.
Have a follow-up, Madam Chair?
Yes.
And my understanding, Senate Bill 248 is not necessarily resulting in some being held pending trial. It's simply to they're going to still have their bail hearing, but wouldn't that hearing just simply be before a judge as opposed to a bail commissioner?
Yes, and that's why we support HB 46. That ensures that someone gets before a judge right away. They're not unnecessarily held. So if the concern really is getting people before a judge right away, then that bill, which would swap out bail commissioners with magistrates, ensure that magistrates are under the judiciary, trained, all the issues we've heard with bail commissioners. That solves that problem, that concern, and it does so in a way that does not unnecessarily detain anyone longer than if they're determined to be dangerous at that level, then they'll be held pre-trial, which is the way the process should work.
Yeah, I understood the quote that you provided to the committee involved someone being held in detention pending trial, not pending their arraignment. So that's where my confusion was. I apologize.
Hey, are there any further questions? Seeing none, thank you very much.
Thank you very much.
And the chair will call Jeff Odland. I'm not sure if I got that correct. Good afternoon, Mr. Odland.
Good afternoon, Senator. Thank you for allowing me to address you today. My name is Jeff Odland. I am a resident of Amherst, New Hampshire. I've been a criminal defense lawyer in the state of New Hampshire for just shy of the last 15 years. And I'm testifying before this committee today in my capacity as the president of the New Hampshire Association of Criminal Defense Lawyers. In sum, what I would urge the committee to consider is to keep the current bail regime in place because the system we have right now is focused on making individualized bail decisions that are specific to individuals in front of those decision makers rather than basing the decisions and the rights on a category such as the charged offense. I want to get a little bit into the details of the current system, how it works, and speak to some of what the senator has said about how this does and doesn't change the current regime. But before I go there, and the Chief Haldenberg expected, I think, that there might be some pushback on this, but I think that the senators should take a hard look at whether there is a crisis in front of us at the moment. When you look at overall crime data in New Hampshire, you'll see that New Hampshire is the second safest state in this nation. This body, our legislators, our law enforcement is already doing an excellent job at keeping our community safe. And that hasn't changed since bail reform passed in 2018. You've heard something of this flavor from other folks that have addressed you, but I'll point to some specific data. If the senators or their staff go onto the publicly available information that the FBI compiles on their publicly available Crime Data Explorer, you can see what the rate of violent crime per capita has been in New Hampshire. The number starts at 195 violent crimes for every 100,000 citizens in 2017. It goes down to 177 in 2018. It goes down to 158 the year after bail reform comes in. It goes down to 146 in 2020. The data is not finalized for 2021. So if you go on the FBI's website, you won't see a hard number. Because my understanding is not all the jurisdictions reported their violent crime data into the FBI. It appeared that over 90% of jurisdictions did, and that the number in 2021 would have fallen further still. So there has not been an increase in violent crime, at least as far as the federal government and the Federal Bureau of Investigations believes, and that's based off of the reporting of violent crime from our law enforcement into the FBI. So with that backdrop, I'd like to speak a little bit about the way the system currently works and piggyback on something that you heard from Captain Treffery. When an individual comes into the police department charged with any type of crime, but in particular, I'll say the crimes that are in the bill that would be affected by a change in the law, they're going to see a bail commissioner the night of. I think that for defendants, defendants' families, criminal defense lawyers, the scenario that probably has the most salience is an individual that is arrested on a Friday. And that's because that individual, as I read the bill, could be held until they see a judge on Tuesday, and in essence detained for 4 days without any process. You heard from Captain Treffery that his experience is that if an individual is charged with a serious offense, they will make a recommendation to that bail commissioner to preventatively detain that person. And I believe he said 9 out of 10 times, that's what occurs, okay? The question here, and this legislation, is really aimed at saying that 10th person, the 1 out of 10 that the bail commissioner doesn't see it for, that thinks that they should be admitted to bail, they shouldn't have an opportunity to go home that night. They should be held up to 4 days with no process. That's the issue. And so when I say to you that the current system looks at individual circumstances, that's where that decision is being made about what is this particular defendant in front of me showing as far as risk. Now, the crimes that are delineated in the bill, I think we're selected clearly for a reason. They're some of the most serious offenses in our criminal code. However, having been a practitioner for 15 years, I could come up with hypothetical scenarios that don't stretch the imagination that I think would give people pause about mandating that someone be held for 1 to 4 days without seeing a judge. So 2 thoughts that came to mind is one of the offenses that is contained is a stalking charge. Stalking charge, some folks don't know, can be charged and is most frequently charged when people violate a no contact provision. That might be a bail provision, it might be a restraining order, even a temporary restraining order where there has not been an adversarial hearing. I have seen cases, for example, where there's a restraining order between divorcing husband and wife, and it's violated because one of the other party texts and says, tell the kids happy birthday, tell the kids Merry Christmas, that's a criminal offense. It should be dealt with through the courts. This legislation would make it so that if someone sent a text message, tell this kid happy birthday, they're going to be held for 4 days now. Similarly, I think this is an interesting analogy. If you think about what happened during the U.S. Supreme Court's confirmation hearing for Justice Kavanaugh, an allegation of a sexual assault that came forward decades after it was alleged to have occurred. Under this legislation, if a complainant came forward and said, I was sexually assaulted by defendant X 18 years ago at a party, and a warrant issues, and the law is, to be clear, that a complainant's testimony, if believed, can sustain the charge, so there would be probable cause, that person would necessarily be held on bail for up to 4 days, even if they protest their innocence, based on a claim that 18 years previously, some serious crime had occurred. And despite the fact that they may have been a law-abiding citizen who has never been arrested in their life. Now, in many cases, are these somewhat extreme examples or potential outliers? They are. But what I would stress to the committee is they're the 1 in 10. They're the 1 in 10 that right now our bail commissioners have the ability to make a judgment call and do what they think is in the interest of justice. That, unfortunately, the bill would strip away that ability to look at individuals with individual circumstances. 2 related issues. Number 1, you heard from the ACLU, but I would reiterate, having seen it in real life, people's lives can be seriously affected by being detained for 4 days. People can lose child care. They can be unable to care for the elderly. They can lose their employment. These things have knock-on effects for the individuals. They have knock-on effects for public safety as people spiral further out of control, become overwhelmed by poverty, mental illness, and substance abuse, even if they've been wrongfully convicted, wrongfully charged. There are cases that the committee can look at in the press that are sort of the other side of the coin of people being treated very harshly by the system. And certainly this committee must and should consider the victims of crime. But the committee should also balance that against the fact that there are individuals held for crimes they did not commit. And I would point the committee to, in particular, an example which is anecdotal, but I think it counterbalances some of the other examples we've heard today of the State versus John Thomas. This was a case where a 18-year-old young man was alleged to have made a threat about his graduation. He was alleged to have said words to the effect of, I wonder if I'm the only one bringing a loaded handgun to graduation, or words to that effect. He was held for months, preventatively detained. He had a jury trial and was acquitted by a jury of his peers. He will not get those months back. So there are interests on both sides of this bill. There has to be a balance struck. And what I would ask the committee to consider is that crime, we have not seen data to suggest that crime rates have risen due to bail reform. The system, there are cases where individual decisions will be made incorrectly because this is a system of human beings making judgment calls about human beings. But the system as currently constituted properly balances an individualized approach to determining whether someone's liberty should be taken from them without any opportunity to see a judge, even if for a period of 1 to 4 days. And I would urge you not to pass the legislation and to keep the current bail regime in place.
Thank you very much. Please stay.
Answer questions. I apologize, Senator.
That's okay. Thank you very much for your testimony. Are there any questions from the committee? I have a few questions. Are you aware of the fact that shortly after this, the original legislation passed, that I would say between 6, maybe I wouldn't even say 6 months after it went into effect, we started getting complaints, the legislature, senators, from our constituents about this very issue. So it wasn't that this went into effect and then all of a sudden, everything was hunky-dory, everything was fine, and then boom, all of a sudden we started having all these problems. These problems started arising almost immediately. Would you believe that?
If you represent, Senator, that you have received many calls from constituents, I'm sure that that's true. I do think that bail reform, as it was debated initially, was, part of a larger criminal justice reform. And I think that, it's easy to think that individual cases are a result of bail reform. But again, I think when we look at the overall hard data and statistics, the crime numbers have gone down. But let me just take as a given, Senator, the supposition that maybe the data is not capturing everything and maybe crime is on the rise, even though that's not what I'm seeing in the hard evidence. There's been no testimony today that the issues that we've seen can't be addressed by the tools that are already available. So preventative detention can be sought by the police in addressing that bail commissioner and can be sought by the prosecutor once the matter is arraigned, and the same exact legal standard that's proposed in this change. The only difference we're talking about really is this limbo period, and saying these people charged with these offenses can't see a bail commissioner. That request for preventative detention can be made right now. And if it's denied by the bail commissioner, the statute actually allows the state to file a petition in the Superior Court for an expedited hearing to argue that the bail commissioner got it wrong. I've never seen a prosecutor in my 15 years ever do that, Senator. It could be done. With respect to, and this is a bit, I think, more on the next bill, but with respect to recidivism concerns, which have been raised by the chiefs, motions to revoke bail are permitted under RSA 597:7-A. Additionally, there is a portion of the standard bail and recognizance statute, 597:2, that says that a 72-hour hold can be placed on someone if they're alleged to have committed a Class A misdemeanor or felony while on bail for a prior offense. So these are tools that are built into the existing law to allow someone to be held, to allow the prosecutor to file a motion to revoke. And so, as Professor Scheer said, I think the question isn't really about a need for a legislative fix. The tools and the toolbox are all there. It's a question of administration of the current statutory scheme. I think that the committee should be wondering, when you hear from Chief Oldenburg about a gentleman released 8 times, why wasn't a motion to revoke filed? Why wasn't a request to detain for 72 hours in order to lodge that motion to revoke filed? Now, the police aren't in a position to file that generally. The line prosecutors would be. But these tools are already built into the law to stop this sort of recidivism from occurring. There appears to be some issue with the way that the state is currently trained or is just willing to use the tools that exist. And my argument to the committee, again, is that even if in individual cases, the criminal defense bar is going to argue for the release of their clients, that prosecutors using the tools that we already have is a better system because it deals with a specific individual defendant and says, this defendant has 2 prior arrests and now he's charged with stalking. We need to have him held, versus a categorical decision-making at the legislative level that doesn't discern any of the particular facts and circumstances of the individual or the crime that's alleged to have been committed.
Thank you for answering my question. I do have one more. You cited a lot of statistics about crime and how crime has gone down. Do you think that that data has been, I would say, skewed because of COVID, because of the lockdowns and how people were staying at home and they just weren't going out or doing a lot of things. Do you think that has any effect on what you claim is a decrease in crime?
I would assume that COVID would have led to a decrease in crime, Senator, but I would also note that that decreasing trend that I cited starts in 2017. So it's going from 2017, 18, 19. So it's pre-pandemic trend that continues all the way to the present day. So while I do think there would be an expectation that folks being at home more might lower crime, although I would point out that the FBI crime statistics show that the overwhelming most common place for a crime to occur is within the home, I would have expected crime to go down. I think a countervailing point that I would make, however, Senator, is that to the extent that crime, there is no evidence that crime is going up, but if it were, I don't know that that necessarily follows that bail reform is somehow responsible for that. When we hear about the difficulties that the Manchester Police Department has had, it's well known that Manchester has struggled with substance use disorder issues, with homelessness and housing issues over the past few years as well. And there's nothing in any data that I've heard that would say that increases in rates of addiction or homelessness are not to blame. The real problem is the workability of the bail statute. I don't think there's any evidence for that, Senator.
Thank you. Are there any questions? Senator Abbas.
Thank you, Madam Chair, and thank you for taking my question. I agree that, and I've seen several different studies showing New Hampshire is one of the safest states, if not the safest state in the country. With that being said, is there, just because it's a safe state, is there a reason why we still don't strive to do better? If we can still make the state less violent, still protect victims of violent crimes? Because the victims of violent crimes, simply because they're in the safest state in the country, doesn't change the fact that they're a victim of a violent crime. So shouldn't we still be trying to strive to do better?
We should always be striving to do better, Senator, of course. I think what I would say, however, is that we can't detain every single, the perfect system that would have zero recidivism is we detain everyone accused of a crime and no one ever gets out, right? But that is both not cost effective, not consistent with American values, with the presumption of liberty, et cetera. In the past, in an interest to get crime to as close hypothetically to zero as we possibly could, we've fought the war on drugs, and we have over-incarcerated individuals for decades long. There's new thinking about that issue, right? And I think the suggestion that's being made is that bail reform was a part of that reform, but the pendulum swung too far. And now that there's an increased danger on our streets as a result of that pendulum swing. And I'm simply saying that the data doesn't bear it out. And that, we have to balance the liberty interests of people who are presumed innocent against the need to protect public safety. And that by all indications, public safety, we're doing a very good job on public safety.
Yeah. Yes. Okay, are there any further questions? Seeing none, thank you very much for your
Thank you very
testimony. Are there any other member of the public that would like to speak to Senate Bill 248? Okay, seeing none, we will go ahead and bang the gavel. Close the public hearing on Senate Bill 248. We're going to go ahead and open the public hearing on Senate Bill 249 and recognize the prime sponsor, our own Senator Abbas.
Thank you, Madam Chair, members of the committee. For the record, Senator Darrell Abbas. I represent District 22, which is the communities of Pelham, Salem, Exeter, and Plastow. I am the prime sponsor of Senate Bill 249. Some of the language in this bill may look familiar. It was part of, I believe, what was last term, part of Senate Bill 92 and I believe Senate Bill 294. And this deals, and I know we just had a long hearing on issues of bail. This deals with a separate, completely separate issue involving bail reform. And it's really just replacing one section, which is cited in Senate Bill 249. What this is dealing with is, and it's a probable cause standard, and I'll point that out because that's the arrest standard. If a person is arrested for a drunk driving charge, a Class A misdemeanor, or a felony, specifically we're excluding violation offenses and Class B misdemeanors, with the exception of drunk driving. In those cases, if you are released on bail and you get arrested a second time, and again, that second offense would also have to be a drunk driving, Class A misdemeanor, or a felony. So now you've been released a second time and then get arrested a third time while out on bail. And again, that third offense would also have to be a felony, Class A misdemeanor, or drunk driving. At that point, there would be a rebuttable presumption that if you were not detained pending your trial, that if the person was released, you would not abide by the conditions of your release. Now, that rebuttable presumption language exists in the current RSA, and you can even see the part that would be is crossed out. That presumption exists. This just clarifies of when that rebuttable presumption would be applicable, and it's on the third offense. So we're talking about someone who's been released on bail two times already, now commits a third offense. And again, we're talking about the exception of drunk driving. These are offenses that a person could serve jail time for if convicted. So we're really trying to look at repeat offenders that it's, in a short period of time because the cases are open. What I emphasize here is that if a person, and this is universal, if a person is released on bail, one of the conditions of their release is to not commit a new offense. If there's no consequence of violating a condition of your release, I will suggest that what is the point of having conditions of bail in the first place? There needs to be some accountability here. So we're talking about a third offense really within a short window of time. And the amount of resources that it takes to have to deal with someone who's committing multiple offenses. We had a situation a few years ago, this was during my first term as a state representative. I had got a phone call from a mother and her daughter was charged within a 2-month time period, was charged with 5 times. She was arrested on 5 different occasions for drunk driving. And my response to that person was, well, it's not really the penalty for drunk driving. The person hasn't been convicted yet, but to me, this is an issue of bail. And after the second, third, fourth, why is the person still getting bail? And so this is, again, looking at as what I would say more of a narrow situation. This policy did pass in the Senate, I believe, last term on 2 different occasions. It, I believe, fell short in the House, and we dealt with it there, and there we are. So that's what I hope to do is deal with that, because the repeat offenders, there's a repeat. That's a lot of law enforcement resources that go into that, a lot of court resources go into that, and there is an opportunity for someone who's in distress. I think, and without knowing all the details, specific details of the example I gave of the drunk driving arrest, for a person in that situation, it sounds like that person may have been dealing with a crisis. I don't think it's unreasonable to suggest that, but that person wasn't getting any of the support they needed. And this gives us an opportunity to look at some of those cases and to allow to address public safety concerns, because that's what we're dealing with. So I'll answer any questions.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Seeing none, thank you very much.
Thank you,
Okay. The chair will call Richard Head.
Didn't mean to sign up on this slide.
Okey doke. Thank you. Okay. The chief, I'm looking at chief. The chair will call Chief Aldenberg.
Chiefs made on the first bill, both in this one, this proposed bill, and all of the remarks from the standard testimony and standard in this bill as well.
Okay, thank you. Chief Bromsky, same thing for him also? Okey-doke. Do you, Ms. Sargent, do you realize we're on the third bill, 249?
We do.
Okay. Okay, how about Captain Trefry? Same? Okay. This is good. Same? Okay. The chair will call Frank Knack.
I apologize for slowing down the process.
No, you're fine. Don't worry about it. We're here.
Madam Chair, members of the committee, thank you so much for the opportunity to testify. My name is Frank Knack. I'm Policy Director with ACLU of New Hampshire. I think as you'll see on the sign-in sheet, I did not check our position on this because until I heard the statement, Senator Abbas's presentation, I was not quite sure what this bill was trying to do. And I think we're still somewhat confused. It's confusing the way it's drafted now. Is there a rebuttable presumption or is this a three strikes law? And so I know, as the senator noted, there is rebuttable presumption language in the current bail statute, but it is different than the way it is drafted in this new proposed bill. In that this language around the person shall be detained in pretrial detention, I don't see anywhere in the current statute. So the way the current statute deals with the rebuttable presumption, for example, in this section is, if there is probable cause to believe that a person, while on release for these offenses, committed a new felony class A misdemeanor driving while operating while impaired, there shall be a rebuttable presumption that the person will not abide by that condition. But there's no language about they shall be detained. And so we're not 100% sure what is happening here with this. And I think it's just also, so this could be, I think, argue that this is some type of three strikes law. I'm not quite sure. And I think it's really also important to point out that, when we talk about felonies, people think really bad things. First possession, Schedule 1 through 4 drug possession, simple possession is a felony in New Hampshire under current law. And so I just wanted to lift up those issues and suggest that we have some concerns and are not quite sure the intent. So thank you.
Thank you very much for your testimony, Mr. Knack. Are there any questions from the committee? Seeing none, thank you very much. The chair will call Mr. Odlin.
I will try and be, thank you, Senator Carson. I will try and be much briefer than I was previously. With respect to this particular bill, I would reiterate the points I made earlier about it being categorical versus individual. I would point out that many of the individuals that are arrested for recidivism type incidents, part of the reason they're not held in the first place is that the original offense is quite minor. You may have individuals suffering from mental illness or homelessness who are arrested for trespassing or disorderly conduct. When I practiced in Manchester, there would be unhoused individuals arrested, for example, for being in the roadway with some frequency. And this would then result in them being detained, being appointed a lawyer, and then needing to request a hearing. I do think that there could be considerable costs to the way that the statutory scheme is proposed, because there would need to be a showing of probable cause for the second and third crime in order to trigger that presumption that you should be detained. So I'm pretty sure in order for this to be upheld based on due process concerns, there would need to be a way for a defendant to argue, well, there wasn't probable cause for arrest 2 or arrest 3. That could trigger some sort of an evidentiary hearing with respect to now 2 of the 3 cases, which I think could take considerable judicial resources. And I think that the current statutory scheme really speaks to the concern that already undergirds this. Roman 3 little c does talk about if you have, if there is probable cause to believe you violated your bail conditions, that creates a presumption that there's no combination of conditions that could assure your appearance or the safety of the community. That's the criteria that then would lead to preventative detention. So there's already a rebuttable presumption that when you get in front of a judge, there's a presumption you would be held. But this is saying that you're going to be held by any bail commissioner that sees it, detained, and there's no even automatic scheduling of a hearing before a judge to review that. And as I said, I think the process to do the review would be rather substantial. Additionally, anyone who would be facing a third arrest where they had 2 prior arrests while on bail could be subject to a motion to revoke bail filed by the state of New Hampshire at any time under the statutory scheme. And that's a tool that's already available to the state. And if that would be the entirety of my comments. If senators have any questions.
Thank you very much for your testimony. Are there any questions, Senator Abbott?
Yes. Thank you, Madam Chair. And thank you for taking my question. I understand the point you're making about the determination of probable cause. So if someone's there for their third offense, if there's a probable cause question on their second or first offense, couldn't that be addressed with a separate motion or hearing on the first or second offense? I mean, that's a defense of the arrest in and of itself.
So I guess my concern, Senator, is simply that it's saying if there's probable cause to, I guess I misspoke. I think the hearing would need to be about whether there was probable cause to believe the second and third offense occurred in order to trigger this, you're being held under the way this is drafted. And that it also could apply to misdemeanor matters, which is it would create a sort of new breed of evidentiary hearing, I think, in the district court. And certainly, I would say you don't have to take my word for it. I would encourage the committee to speak to constitutional lawyers to speak about my assertion that I think there would be a due process concern if there wasn't a way to get a hearing to make these probable cause determinations. But, you know, if a court was to agree with this argument, which I'm sure the defense bar would raise, I'm just pointing out that it would lead to a significant increase in hearings, I think. That said, to be fair, when I was saying to you earlier, Senator Carson, that the prosecutors could be filing motions to revoke, that would trigger a hearing on that motion to revoke as well. So either way this issue was dealt with, there would be some administrative cost.
Okay, thank you. Do you have a follow-up, Senator?
No, I'm also, thank you, Madam Chair.
Okay, thank you. Are there any further questions? Seeing none, thank you very much for being here today. Okay, are there any other member of the public that would like to speak to Senate Bill 249? Okay, seeing none, we're going to go ahead and close the public hearing. We are. Thank you. Okay. Okay. Where do you want to get? You're singing. You're singing.
Thank you very much, Madam Chair, members of the committee. I guess I'm thankful that this is a late hearing because I get to see the whole committee compared to most others today. For the record, I'm Donna Susi. I represent Senate District 18, which is comprised of the town of Litchfield and 5 wards in the city of Manchester. And I'm here today to introduce Senate Bill 252 because I think this is an issue that continues to plague our communities throughout the state. You've already heard quite a bit of testimony about bail-related issues, some of it for, some of it against, some statistics that seem accurate, some that don't. But this issue goes back to 2018 when bail reform was first introduced and the changes to the statute were made. I became particularly involved in 2019, and part of the reason for that is because, much like you, Madam Chair, I continue to hear from my constituents in Manchester that changes that occurred, whether in their minds, real or perceived, have changed the complexion of our criminal justice system and have created concern within the community. And I think each one of us is here to represent our constituents. This is a very complicated issue, and I think we have to take it very seriously and very deliberately, but I do think we have to raise the concerns that are expressed within our own communities. You've heard dozens of anecdotal stories. You've heard a lot of statistics. I've heard many of those, and you may hear some in testimony following me. But I think what's of particular concern, and the anecdote that I've heard repeatedly, and I've actually heard it from some individuals, is that because of the greater prevalence of personal recognizance bail, there are crimes going unreported, particularly in the area of domestic violence. There are people that are suffering and not reporting crimes as a result of their fear that if they do so, the return of the alleged perpetrator will cause more harm to them and to their families. And that's an issue that I think we have to take seriously and we have to take a close look at. I think one of the biggest problems, and it is probably illustrated in the testimony that you've heard from people on both sides of this issue, when this change happened, the infrastructure to accommodate the change really was not in place. And I'm not here to argue magistrates, I'm not here to criticize bail commissioners, I'm not here to criticize judges. But I will say that it appears that even to this date, there are inconsistencies throughout our counties in how these decisions are made. Factors are weighted differently, and I recognize that that's judicial discretion, but weighted significantly different throughout the state. And in addition, I think that a number of our bail commissioners and even some of our judges, although trained, really need more training and more consistency in the application of this process to the defendants. So very quickly and simply, what 252 would do is to identify specific crimes, the most violent of crimes, and require that a person go before a judge for consideration of bail. It was stated earlier that this would mean days. It does not necessarily mean that if the court system is able to accommodate these individuals as quickly as they are brought forward. In many cases, I think it would happen in far less time. It would not require the extensive detainment that was described earlier. But I would ask the committee to carefully consider each one of these pieces of legislation. I know you have several before you. This one, much like the one presented earlier by Senator Abbas, really tries to deal with a discrete problem and those most serious crimes that are delineated. With that, I'd be happy to take any questions. I do have the Mayor of Manchester who would also like to testify, and I know she's been here for quite a while, and the chief and other chiefs are available for more technical questions as well. You might get more detailed answers from them regarding this.
Thank you very much for your testimony, Senator Susi. Are there any questions? Senator Whitley.
Thank you, Madam Chair. Thanks for taking my question. So the first one is, wanting to know the substantive differences between your bill and 248, just so we're aware.
There don't appear to be. For some reason, they have different titles.
Okay.
but they essentially do this, I shouldn't say essentially, they do the same thing. And I think I've certainly spoken with Senator Abbas, and would certainly welcome speaking with all of you in a public setting, unless it's just one, to talk about how we resolve that if we were to move forward with one bill or the other, or to find a way to incorporate those changes.
Follow up.
Thank you for taking another question. So this is one that, I talked to Senator Abbas about too, and something that I'm struggling with is, what is going wrong with the current system, right? And so, looking at the current law, there are tools to hold someone, right, for dangerousness. And one of those tools includes, prosecutors or the state, challenging a release. So why isn't that being used? And do you have any sense, any sort of numbers there, why that's not being used? Or is there a hesitance to use that? Anything you can do to eliminate that?
Sure. So I don't have any specific numbers as to why or when it is used, how frequently. But what I can tell you is it is yet another part of the infrastructure problem that I think we suffer within the criminal justice system. And that is that you do have quite a bit of inconsistency amongst the attorneys. County attorneys are elected. That's not a critique of whether they're good or bad, but they are elected. So they're subject to change every 2 years. Their offices, particularly now, have had a great deal of turnover. And once again, I don't know that there's the ability to provide the more intensive type of training that a lot of these people need when they are carrying extraordinary caseloads and trying to focus their energies and resources as effectively as possible. I think it's potentially slipping through the cracks. I hate to say that, but I think that's what's happened in some cases.
Follow up?
So in a perfect world, with your magic ball looking into it, if those infrastructure issues were resolved, if we had the highest caliber prosecutors across the board, they had the same training and it was, perfect. Do you think that the current system would need to be changed?
It's a good question, Senator. I think it would probably need less change. I still believe in the case of the most violent alleged offenders that a judicial requirement would still be necessary. I also think in order to get to that perfect world, and I like to envision like Disney World, that to me would be, pretty perfect. It's going to take us years to get there.
Thank you.
And I think in the interim, we have to take some precautionary steps.
Thank you. Are there any further questions? Seeing none, thank you very much.
Thank you.
The chair will call Mayor Joyce Craig. Good afternoon, Madam Mayor.
Good afternoon. It's a pleasure to be here, Chairwoman Carson, and to the committee members. Thank you. My name is Joyce Craig, and I am Mayor of the City of Manchester, and I'm here to speak in favor of Senate Bill 252 relative to release of a defendant pending trial. And I urge the committee to recommend this bill as ought to pass to the full Senate. As mayor of the largest city of the state, the safety of our residents and visitors is my #1 priority. I work closely with the men and women of the Manchester Police Department in preventing and addressing crime in our community. And while well-intentioned, the statutory changes made in the name of bail reform in 2018 have had negative consequences in the city of Manchester. I agree with the overarching premise of bail reform. Individuals should not remain in jail solely because they cannot afford bail. However, until the state and county governments implement uniform and comprehensive pretrial services, the bail reform that was passed in 2018 will continue to be unsuccessful. Regardless of pretrial services, violent offenders and those posing a risk to harm members of our community should not be released on personal recognizance. Senate Bill 252 would require that individuals accused of committing egregious crimes such as homicide, aggravated felonious sexual assault, or domestic violence must be detained pending an arraignment before the court. This bill will ensure that a judge is able to make a well-informed bail term assessment, necessary information available. The Manchester Police Department conducted an analysis of arrests for the 12 months prior to bail reform compared to the 12 months after bail reform. Their assessment showed that post-bail reform, Manchester saw a 20% increase in arrests of offenders who were out on bail. And as Hillsborough County does not have adequate pretrial services, our officers have limited ability to ensure that bail conditions are met. The actions of this legislature have consequences in our local communities. I provided testimony for a similar bill in February of 2022, in which I urged the legislature to act to ensure the safety of our residents. But in the 2022 legislative session came to close without these necessary changes. In September of 2022, a 75-year-old resident of Manchester, Daniel Whitmore, was murdered. The Mississippi man who was charged with his killing had been arrested in July for an attempted stabbing and criminal threatening, but was released on personal recognizances. Then, just days before Whitmore's death, the accused was arrested again in Nashua, violating his previous bail terms. He was transported from Nashua to Hillsborough County Corrections in Manchester and once again released on personal recognizance onto our streets. This tragic outcome could likely have been prevented with changes to our bail system. I am once again urging this legislature to move forward with this common sense bail reform. It is one step that we can take to help ensure the safety of our communities. I ask you to recommend Senate Bill 252 as ought to pass to the full Senate. Thank you.
Thank you very much, Madam Mayor. Are there any questions from the committee? None? Seeing none, thank you.
Thank you.
Senator D'Alessandro, I see you here. Would you like to come up to testify? You're all set? Okay, thank you. Okay. Next, we're going to call Richard Head.
Thank you, Madam Chair. Members of the committee, my name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I just came up to say that with the Chair's permission, I would incorporate my testimony from Senate Bill 248 into this bill and would have no other additional comments other than what I previously testified to.
Okay, thank you. Are there questions? Okay, seeing none, thank you. Okay, let's go to Chief Aldenberg. Does he wish to speak again? Okay. Okay, Chief Bronski? Good afternoon again, Chief.
Yes, good afternoon again, and I'll be brief. I would request that the committee consider my previous testimony on a companion bill earlier today and my written testimony that I've been submitted in support of this bill on behalf of the New Hampshire Association of Chiefs of Police.
Okay, thank you very much. Are there any questions from the committee? Okay, seeing none. Thank you.
Thank you.
Let's see. Let's go to Mark Hall.
Definitely not, Chairman. We are in support of this bill.
Please have a seat and introduce yourself into the microphone.
My name is Mark Hall with the New Hampshire State Police. We are in support of this bill. However, I don't have any testimony to offer outside of what my colleagues have already covered today.
Okay, thank you. Any questions? Seeing none? Thank you. Okay, let's see. Let's go to June Trissiani. Hope I didn't butcher it too badly.
Well done, Madam Chair. Thank you for your time today. I know it's been a long day. I am June Trissiani. I'm an alderman at large for the city of Manchester. However, I am today speaking on behalf of myself and my community members, and this is not reflective of my fellow board members. I am here to speak in support of Senate Bill 252. While I appreciate and support the spirit of the current bail reform law, I feel that we're doing an injustice to public safety with the laws it's written today. The bill as proposed today strengthens the language of our current law by identifying a series of violent crimes that would require a person to go before a judge to determine if they are harmful to themselves or to others, rather than being immediately released on personal recognizance bail and putting the general public and victims at further risk for a repeat offense. You've heard from Chief Aldenberg of Manchester. You've heard from Mayor Craig, so I will not repeat the stories. However, I ask that you consider the victims of these violent crimes and their families and our Manchester community when making your decision today. I see this language as a compromise. I'm not here to take away the rights of a person who is charged with a crime due to their inability to pay bail, and this is not the essence of these proposed changes. I believe that the revised language keeps the spirit of the law intact to ensure that judges and bail commissioners are being thoughtful when setting bail for a person who is poor and charged with a nonviolent crime to ensure they are not being unfairly jailed prior to their trial. Today, I'm asking that you vote yes and push this to the full Senate for a yes vote. To add these revisions of violent offenses to the law to trigger a bail hearing before a judge, so the merits of the case will be reviewed prior to releasing an individual on personal recognizance. In Manchester alone, as you've heard the stories, we've seen people released and only be arrested hours, days, or weeks later for similar violent offenses, causing death or additional harm to the victims that they've already violated. Thank you for your time.
Thank you very much for your testimony. Are there any questions from the committee? Thank you. The chair will call Jeff Odland.
You senators again. I would just ask that my Jeff Odland on behalf of the New Hampshire Association of Criminal Defense Lawyers, for the record, I would just ask the committee that my prior comments with respect to Senate Bill 248 be incorporated into the record, as the substance of these bills are in essence interchangeable as far as I can tell. I would just briefly reply to the testimony offered by Mayor Craig, which was an echo of Chief Oldenburg. One of the things that we were taught as trial lawyers in law school is that statistics are boring, but stories are powerful. And I think the most powerful story we've heard about here today is this incident involving the gentleman in Manchester charged with an attempted first-degree assault, released on bail, who later is alleged to have killed someone. And I would just ask the committee to recall and incorporate into its consideration of this bill as well the testimony of Professor Scheer. He testified with respect to 248 that he reviewed that file and that that gentleman was released on bail on that first-degree assault after a contested hearing in front of the Honorable Will Delker. And so that is a powerful, tragic, horrible story for our community. But this bill, which would push off all bail decisions to a judge, would just get us to the same scenario as what happened in that matter, where the bail determination was made by a judge, and unfortunately, tragedy later occurred. And so I'd ask the committee to consider whether this bill as drafted is the fix for the problem that's before the committee.
Thank you very much for your testimony. Senator Abbas has a question.
Thank you, Madam Chair. And thank you for taking my question. The captain from Nashua provided an example of someone who was arrested for domestic violence and let out within 4 hours by a bail commissioner, and then broke into someone's house, the same victim's house, and actually battered her again and sexually assaulted her in her own home. Do you believe that under that scenario that Senate Bill 252 would address that situation?
Well, it would appear that certainly that 4-hour window would be impossible under the bill, Senator. So I think to the extent that that is the concern, I mean, that exact fact pattern, yes, I think it would not be able to occur under the law as written. Consistent with my prior comments, I would just point out that that seems like an unusual bail determination. And I think that we could look instead to the way that the current law is being administered and learn. I think the committee should seek more information about why bail determinations are being made by bail commissioners to release people in situations that we would be surprised they would be released under. I do think also a judge could ultimately make the very same determination, but I think to your point, Senator, you're correct that because the judge wouldn't see the individual until the very next day, you wouldn't have that 4-hour turnaround like you had in Captain Treffery's testimony.
Thank you. Okay, are there any further questions? Okay, seeing none, thank you very much.
Thank you.
And the chair will call Frank Knack.
Madam Chair, members of the committee, thank you so much for the opportunity to testify. My name is Frank Knack, Policy Director with the ACLU of New Hampshire, here in opposition to SB 252. So much of my testimony in the identical SB 248 will be the same here, so I won't repeat myself. I'll just touch on a few additional issues that came up in prior testimony on this bill. There's testimony that this bill is important because it would help create a uniform system to determine whether someone should be held or not. And again, I point to my previous testimony. If we're really concerned with having a uniform system, ensuring that everyone gets before a judge on the front end, then there's a bill in the other body, HB 46, that replaces bail commissioners with magistrates. It'll ensure that everyone gets before a judge on the front end, while also ensuring that no one is unnecessarily detained, which under this bill, they would be detained for multiple days. And again, as we talked about in the last bill, experience the multiple collateral consequences that can impact them, but also family members that may rely upon them. Again, we heard kind of horrific stories of the murder in Manchester. We heard again of the incident in Nashua. And again, point out what we didn't hear in either of those cases is concrete examples from the individuals bringing those examples of how the current bail system failed. Did they challenge did they challenge the release order? If the person reoffended, did they try and revoke? Again, we heard none of that. And when we did hear testimony from Professor Scher on the SB 248, we did hear in that testimony that those tools were never utilized in the Manchester case. In the Nashua case, we have seen no facts to support that. And I'm happy to leave it at that. I don't want to play repeater. I apologize.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none.
Thank you all
very much. Are there any other member of the public that would like to speak to Senate Bill 252? Okay, seeing none, we'll close the public hearing. Yeah, you order dinner, so you're gonna pay and eat. This, no, I know, I need a drink of water or something.
Thank you, Madam Chairwoman. Nice to see you guys again. Second day in a row. Madam Chairwoman, members of the committee, I am Senator Rebecca Perkins-Coca, for the record, from District 21, here to introduce SB 254 relative to community-based sentencing alternatives for primary caregivers. The intention of this bill, first and foremost, was to address the impact of incarceration on children and families in our state. Incarceration of nonviolent offenders who are primary caregivers and supporting children who have an incarcerated parent is a topic worth exploring. Without question, ensuring the safety of victims and children in our state is of the utmost importance, and discussion of this bill leading up to the hearing with many stakeholders has shown that this would be better served through a working group of state stakeholders. Therefore, I respectfully ask that you ITL this bill in order to allow the time needed for these state stakeholders to come together and have the nuanced discussion this topic requires. Thank you. Thank you.
Senator Carson, your mic.
Thank you very much, Senator Perkins Coker. Stephen Idris, I think he might have left. I'll call you next. Yeah, please introduce yourself for the record. Okay. Okay.
Is your mic on?
Nope. There we go.
Sorry about that. That he had checked and that all 10 county attorneys opposed the bill.
Okay. Okay. Are there any questions? Okay.
So I was going to speak in opposition. My understanding is that that's
But
not
please,
necessary.
if you have something that you would like to add.
Nope, I don't.
Okay. Senator Whitley has a question for you.
Thank you, Madam Chair. Thanks for taking my question. So
Sure.
Senator Perkins Coker said, what I heard from her is that, she's wants to convene a working group. So wondering if you'd be interested in participating in that working group.
Certainly, I can talk to my boss and see about that. If he'd like to participate, we do have a lot of concerns with the bill, but certainly, as I told the senator, I'm always happy to discuss the issues that we see and talk about it. I think that could be fruitful. You're very welcome.
I do have a question. You just said that you had a lot of concerns about the bill. What were some of the concerns that you had?
Okay, so starting off with, it's not clear to us why this bill would be necessary. I did check with the Department of Corrections and learned that over the last 9 years, that the number of incarcerated inmates in New Hampshire has dropped 30%. And out of that number, as of January 1, 2023, only 135 of those inmates were women. So it's apparent from the numbers that New Hampshire does not have a problem with what's called mass incarceration. And when I did go on the websites of some of the organizations that were championing this type of bill, and one of the big issues for them was the issue of mass incarceration, which is what prompted me to look at New Hampshire's numbers. So it doesn't appear that we have that issue here in New Hampshire, and certainly to the extent that the bill is considering caregivers who might be female, it's very clear that that number is exceedingly low. By my calculations, less than 7% of the inmates in New Hampshire are female. So that's clearly not that issue. As far as the reason that the bill is also not necessary, it's because in New Hampshire, judges have broad discretion to consider all kinds of different factors in sentencing. And I can tell you that based on my experience, and I think you would hear it from other colleagues on both sides, prosecution, defense, courts are always open to hearing all kinds of information, talking about not only the prosecution's view of things, but the defense's view of things, including circumstances about the defendant's background that could bear on what's the appropriate punishment, why did the defendant commit these particular acts, regardless of what they are. So the things in the bill talk about, does somebody have a dependent, regardless of that person's age or condition. That is something, if that exists, it's something that the defense attorney does bring up, and it's something that the court already can consider. The courts have at their disposal mechanisms to suspend sentences and defer sentences, meaning unless it's a case where there is a mandatory minimum sentence, and there are very few in New Hampshire, very few crimes where we have that, a judge always has discretion whether to impose any jail or prison time at all. Always has that discretion. So there's really no need for this bill to go that additional route. The other issues that we see with the bill are, it doesn't distinguish the types of defendants who could fall within its umbrella. For instance, the bill talks about the fact if you have a dependent, whether it's somebody under a certain age or over a certain age, it may be that your crime actually involved crimes against those dependents. And so the bill doesn't take that into account. And it creates a special class of people. Just because you have a dependent doesn't mean you're not responsible for the crimes that you committed.
And so those are some of the issues that we saw with the bill. The last one is there's a line in the bill that says essentially that the court at any point can amend the terms of the sentence, including completely cutting the sentence. That has a couple problems. One is our Supreme Court says that defendants have to be told what the terms of their sentence are at the time of sentencing. So it would actually be unconstitutional to then change those terms, good or bad, because the bill wouldn't distinguish. So a defendant might be told, you get a 12-month sentence, but then under the terms of this bill, they could come back and be given a sentence of many, many years in prison. That would raise many, many issues. And obviously not be fair to the parties not to know what the terms of the sentence are. So those are just some of the issues that we saw with the bill. That's just a quick summary.
Okay, thank you. Are there any questions? Thank you. Thank you very much for your
Thank you for letting me
testimony
speak.
this
I appreciate
afternoon.
it.
Thank you. The chair will call Lynn Charlotte. Good afternoon, Ms. Charlotte.
Good afternoon, Madam Chair and members of the committee. My name is Lynn Chalette. I'm the Executive Director at the New Hampshire Coalition Against Domestic and Sexual Violence. And I think we can also be relatively abbreviated. We appreciate the sponsor's commitment to ensuring that children and dependent adults are living in a safe environment. And we would be very open, I can anticipate your question, Senator Whitley, to working with the work group to address a number of the concerns that we had on this bill. I'm happy to take questions, but I realize it's late in the day.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you very much.
Are there any other members of the public that would like to testify on Senate Bill 254? All right, seeing none. Okay, can a motion go to executive session?
Don't we move one more?
Yep, but
Oh, we're just,
way
oh, yeah,
beyond
yeah,
our
yeah.
time.
I'm sorry.
so-
Yeah, yeah.
Okay, we have a move to go into executive session. Is there a second? Seconded by Senator Gannon. We have in front of us Senate Bill 254. We've had a request from the sponsor to ITL this bill. Is there a motion on this bill?
So moved.
Moved by Senator Gannon
Second.
to ITL, second by Senator Abbas. Is there any discussion on the ITL motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion?
Consent.
Okay, Senator Gannon moves consent. Is there a second by Senator Whitley? Is there any discussion on the consent motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay. Who would like to write the little blurby on this? Okay, Senator Whitley will do that. Okay, can I get a motion to come out of executive session? Moved by Senator Whitley, seconded by Senator Chandler. Okay, oh, all in favor say aye?
Aye.
Aye. Any opposed? It's late. It's been a long day. Okay. That way we just get to bed. Open the final bill of the day, Senate Bill 264, and recognize the prime sponsor, Senator Perkins Coker.
Hello, committee members, and congratulations on being near the end of the day. Madam Chair, members of the committee, for the record, I'm Senator Rebecca Perkins Coker from District 21, here to introduce SB 264 relative to parentage. Parenthood is a dream for many people. That dream can be achieved in a variety of ways. Some people, like my wife and I, need to turn to help from medical professionals, and New Hampshire has been a leader in this area to protect children born through assisted reproduction. This bill will allow parents, all parents, including those who have become parents through assisted reproduction, to use a simple affidavit to affirm their parental rights as opposed to having to go through a full confirmatory adoption process and hearing. This allows New Hampshire families to use our judicial system most efficiently, as well as feel their rights are protected in a simple, easy-to-use way. I know this process firsthand as I adopted both of my daughters, though I carried and gave birth to them, because that is still the advice for same-sex couples. This bill would open a more efficient route for families like mine. Also in this bill are some updates to the law that have been raised by the practitioners in this field. Families do come in many shapes and sizes, and so allowing our procedures to reflect New Hampshire is a smart way to reduce complications in the judicial system and make the process more open and streamlined. I won't review those changes in detail, but there is someone here who can do that for you. But know that the intent for the majority of the changes is simply to have some cleanup language from those that are practicing in the field. I'd also like to mention there's one change, and I believe Ms. Tucker is testifying behind me will address it in more detail, but there's one change we'd like to make on page 2 to line 14 of the bill that we just didn't catch, to replace the words gestational carrier agreement to assisted reproduction. And so to change the words gestational carrier agreement to assisted reproduction. And Catherine will speak to the substance of that change. And then lastly, I'd just like to mention that we noticed after this had been scheduled for hearing that the fiscal note attached to this bill is actually related to an earlier version of it. So we're expecting an updated fiscal note to come through, but there really shouldn't be any fiscal impact resulting from this. In fact, our hope is that it streamlines some of the judicial processes and so actually saves costs. But I will leave that up to LBA to opine on. Thank you, Madam Chairwoman. I'm happy to take any questions that I can answer.
Okay, thank you very much for your testimony. Senator Gannon has a question.
Thank you. The intent of your bill, everything's fine. It just seems like at certain places, I know we're very close in districts, we're both Seacoast senators, but I know they're building a bridge, but it seems to be a gap between, in some ways, between our people. Just the terminology, and it was, as you know, I've had this issue with other bills from inmate, I think we had last year, Senator Whitley. And so terms and words are very important. And so Latin, I thought Lou's gone, so I won't use my Latin because it's very limited. Gestare means to carry. It's an old word. So all over the place you have gestational carrier and you're crossed out woman. It bothers a lot of women in my district. It's a process, gestation process, or period of developing inside the womb between conception. Only a woman has it. So it bothers some of my voters and constituents, and they're saying, like a woman's vagina, you have to cross that out. These are female reproductive terms. Why do you have to be, the word in my district, why do they have to be so woke? What are they trying to do? I don't mind pronouns, he, she, I'm getting used to that, them, they. I'm fine with that. But on some things like this, it's a woman's, I can't carry, right? I'm from a farm family in Ireland, and when they have the sheep, it's only the female sheep, and we don't milk the bulls. So just these simple terms, what are you trying to do here? Because the intent of the bill is fine, just the words are problematic to a lot of New Hampshire residents.
Yeah, thank you, Senator Gannon. I can't personally attest to all people who have the experience of not identifying with a male or female pronoun. It is my intent in this bill to change the language just to be inclusive. I think that it's important for us to be inclusive in New Hampshire as a value, but I also think for the practitioners in the field, and maybe Catherine can speak to this, people are making sure that they can live their lives as their true selves. And I think that our laws should reflect the people we have in New Hampshire. And whether that reflects our personal experience or not, I still think it's important for our laws.
Follow up though, so I do hear, I've heard people testify that men can have children out. They can't. So why, it's only a woman can bear a child. And it's a wonderful thing. And it's why do we have to try to change the language all throughout this bill?
Senator Gannon, I appreciate your comments and I would love to have your support on the bill. I hear what you're saying, but we did make the language change for a reason, which is that the reality is in our court system that there are people who identify outside of being male or female.
Last follow-up. I realize you may recognize in any which way. And that's fine, and I'll be polite about it in every way. But it's science. I'm always listening to your side say science, follow the science, just basic biology. Why are we trying to change the language?
We are trying to change the language just to be inclusive to our residents, to make sure everyone who lives in New Hampshire feels a part of New Hampshire.
You've answered my questions. Thank you, Senator.
Thank you.
Okay, are there any other questions? Senator,
I'm sorry.
okay, Senator Abbas and then Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. On page 3, lines 3 through 9, three through 9, the existing law says a donor is not a parent of a child conceived through assisted reproduction. But then it adds what appears to be like a procedure to file a petition of non-paternity. Is that something that's available in the existing law, or is that a substantive change to the law?
In lines 3 through 9, a donor may bring a petition for non-parentage to affirm. So I'm going to let Catherine address that, Senator Abbas, but I believe that this is supposed to reflect existing procedures, and that it's important for donors to the assisted reproduction process to be able to protect their rights too. And so I believe they can do that under existing law, but I think we were trying to clarify it. But she's a practitioner, so she'll have a better answer to this question.
Thank you.
Thank you.
Okay, Senator Whitley.
Thank you, Madam Chair. And thank you for bringing this to our attention. I think your life experience, is bringing this issue to us, and I appreciate that. I'm wondering if sort of the changes that we're looking for to, make sure that your families like yours don't have to go through this rigmarole, even though I saw you pregnant, you have carried your child. Is this consistent with what other states have done to sort of line things up and make families, not have to run through this extra hoop?
Yeah, I believe so. And again, I'm not a practitioner in the field. Our job here in the Senate is to make sure we're reflecting the values of our residents, and also to make our state run as efficiently as possible. But I think that what other states have done is similar to this. And in fact, I think New Hampshire in some ways has been very accommodating to these procedures. And so reflecting what the judicial system is doing in our laws will make it more efficient, because even though I found the whole process to be very inclusive and accommodating of our family, I would love to save them the time of answering questions about forms that don't quite apply to us, or, just sort of who is adopting our daughters. I think that making sure our law is clear so that everybody can use it easily is just common sense. So that's what I'm hoping to do.
Yes, follow up.
Thank you for that information. The other thing I was wondering is whether, this clarification would save some families in legal expenses. I know your family and have the means to, get this resolved, but I can imagine that not every family has those resources. And so do you think that this clarification is going to save some families some money?
I think so. I hope so. And Catherine can speak to, the frequency of legal counsel in these proceedings, but, we had to send our forms in 2 or 3 times. And so, I was able to kind of work through that process, but I'm a practicing attorney, and I do think, we want our judicial system to be available to everybody and make it easy and efficient. So that's really the intent here.
Hey, are there any further questions? Senator, I have a couple of questions, and I think some of them are really basically a term of art.
Probably. That
are very specific, so I'm going to hold off those questions. But I do notice on page 5, section E, beginning on line 8, that speaks to, I guess it looks like it speaks to a breach of the agreement. And that it says, beginning on line 11, that such a breach causes harm to the resulting child, the gestational carrier, and then they've crossed out, will cover her potential liability and replace it with may be held financially responsible for such harm. I think that's, in my opinion anyway, it's kind of squishy. You have a contract with someone that they are going to carry a child for you for whatever reason. You might not be able to carry a child, there's health issues, but if that within that contract, there are probably conditions that they have to maintain their health, like no drinking during the pregnancy, no drugs during the dependency. And if you find out that that person has violated the contract, I think the language isn't strong enough for me that may be held financially responsible. Quite frankly, I think probably they should be responsible because they violated the contract. So I just want to kind of get your opinion on that.
Yeah, I appreciate your perspective, Senator Carson. And you're right, this is not a term of art, but I know that Catherine has dealt with how this plays out in the field. And so, I mean, my guess is that the may here is because of judicial discretion and imposing penalties, but I would rather have her speak to that as a practitioner, but I understand your question.
Okay, and my last question is on page 6. Beginning on line 3, where it speaks of the marriage or partnership of a gestational carrier. In looking at this, I think there probably needs to be a definition of what a partnership is, because there are a lot of different forms of a partnership.
Sure.
And if parties enter into a contract, and then you've got someone else who feels that they should have a say-so in this.
Yeah.
I think that all needs to be laid out for everyone potentially involved so that you can safely carry the child, and then when everything is done and over, you're legally handing that child off to someone else. Everyone knows their rights, their duties, responsibilities, and I would hate to have someone interfere in that because they feel they've got a partnership with that person. So I'm just a suggestion, and I see, is it Ms. Tucker? Probably shaking her head, yes. So we'll have a conversation when she comes up. But I wanted to point that out, that I do think that the word partnership needs to be defined.
Okay, that's a great question.
Thank you.
Thank you.
Okay, are there any further questions for Senator Perkins-Coie? Okay, seeing none, thank you very much.
Thank you, Chairwoman.
Okay, why don't we call it Ms. Tucker?
Your name has been evoked enough.
Yes.
Thank you, Madam Chairwoman. My name is Catherine Tucker, and I am a resident of Concord, and I practice law out of my law office in Loudoun. And I'm glad to be here today to talk about something that's working really well in the circuit court. This law works great. My law practice is exclusively assisted reproduction. So I help people with IVF, donor eggs, donor sperm, surrogacy, whatever assisted reproduction issue they have, I help them with. And I've been doing this for 13 years. And like the senator said, there's lots of different families that are formed through assisted reproduction. Families like the senators and families like mine. I mean, we were a straight married couple who needed to use an egg donor. So we were impacted by this. And I am so grateful that our situation was well protected in the law. It's not like that for everybody in New Hampshire. And so we just, when we made the substantial changes to RSA 168B in 2014, we wanted to make sure that everybody was protected. And we did the best that we could at that time. And it was, a bipartisan issue. We had a prime sponsor who was a Republican. Everybody was on board with this. It's good. What has happened is working really well. But, as times change and as I actually get into court and do certain types of cases, I realize that there's some tweaks that are necessary to this law to make sure that we can protect everyone. So let me start with the senator's question about the term women. So there's a reference to a woman's vagina, cervical canal, or uterus, and the suggestion was made to remove the word women. It doesn't change the meaning at all. A vagina, a cervical canal, or a uterus. So I think that is inclusive in a way without having any offensive repercussions coming out of that. So that I just wanted to address that. So I'll start with the name of the statute. It's called surrogacy. But the reality is that this law has been around in some form since the mid-1990s, and it's always covered all forms of parentage, not just surrogacy. The fact that the title of surrogacy has caused some confusion for folks who are not as up to date on the statute as I am, and certainly causes confusion for constituents who don't have the funds to hire an attorney and go looking for the law that's going to help them. They're going to mistakenly think that this law is not the right place to look. So let's update it and make sure that we have an accurate title to the statute. The next change, there's some language about changing the word eggs to gametes. This law currently applies to donation of eggs and sperm, but somebody who doesn't know that may not understand that. So let's get those terms right up to where we need them. We want to clarify that donors can also be compensated. It's not just gestational carriers that can receive compensation, but also donors. There is a problem with the definition of gestational carrier because it inadvertently implies that a person can't be a gestational carrier for their sister, brother, cousin, or any other biological relative. That was never the intention. And so that's a mistake that we should clean up just to make sure that we don't have any problems with that. Next, we've got the language that the senator requested on page 2, line 14, to change the words gestational carrier agreement to assisted reproduction. So this definition is used in different parts of the statute, and in the way it's used, it refers to all types of assisted reproduction, not just gestational carrier agreements. So our definition doesn't match up with the way that the word is used in the statute. So let's update that and make that fix. Similarly, for gestational carrier arrangements, we want to add in that just so that folks who are not familiar with this can understand that we're talking not just about eggs and sperm, but embryos, the embryos that is not coming from the gestational carrier. Intended parents definition, we want to clarify, and it's not even a clarification, this is already true, but let's make it crystal clear for anybody reading the statute that intended parents can be married or unmarried, the same way that parents through sexual intercourse can be married or unmarried. Mental health consultation. So when we wrote this in 2014, best practices where you sit down in the same room with the mental health professional. Then COVID came along. And then all the mental health professionals went to telehealth, and they're only doing telehealth. So good luck finding somebody who can do it in person. So let's, open that up to telehealth. Non-surrogacy parent. So at the bottom of page 2, under Roman numeral 2, non-surrogacy parentage orders were added to the law in, I believe it was 2021. And thank you for doing that. That has helped a lot of families. The problem is that we put in a slightly different legal standard for the parentage orders than what's in the assisted reproduction part of the law. So we need to clean that up. We need to have the same legal standard in both places. So let's make that's what that fix is about. Okay, donors. So a common misconception is that donors just sign away their rights and that's it. That's not how it works. It's not final official until you get a court order saying that that person really truly is a donor. And most of the time we are able to make that work under existing law because the intended parents can use other parts of this statute or they can use the adoption laws to get a court order saying that the donor is just a donor. The problem we run into is that here in New Hampshire, we're actually very progressive on this front. We're so progressive that, all the other New England states started following us and passing their own laws modeled after us, as well as other states around the country. I mean, I'm constantly hearing people talk in other states about, well, New Hampshire did this, let's do that too. So we're very progressive, but not every other state is. And so when we have a New Hampshire donor who's donating to known donors in another state that's not progressive, you can end up with no ability to get a court order to cut off the donor's parental rights. So now our New Hampshire donor is potentially on the hook for child support for this child in some other state. That is not very protective of our New Hampshire donors, and we need to protect our New Hampshire donors. In my practice, I don't see this very often. I see it probably once, maybe twice a year where we run into a scenario like that. But those donors, they need to be protected. And it's particularly a concern in the with embryo donation. So you do IVF, you build your family, and you have some embryos left over, and you want to donate those to another family so that the other family can have their own kids. That's great. It's a wonderful thing. The mental health professionals encourage known donation to happen. The problem that you get with known donation is you really, really need to make sure that the donor's rights are cut off, the donor's parental status is cut off. And there are scenarios with out-of-state recipients where we can't do that for our New Hampshire residents. So if we want to encourage embryo donation, we need to protect our New Hampshire donors. And this is going to do it. And it's also a money saver because now you don't have to get into expensive litigation to figure out who is and isn't a parent of this child. You've got your court orders right up front. You're saving money down the road by avoiding that expensive litigation.
I have to interrupt you because my head is kind of going, what are you talking about? Yeah. Because to look at what you just talked about, you have an embryo. You have a sperm donor, you have an egg donor. Who has control over this? And I know that there's probably lots of case law where somebody did something and then they changed their mind, or somebody died and they want them. Who determines I don't know, is it parentage? Who determines who controls that? Because you have two people that have contributed their bodily cells to create an embryo. And is that section protecting the both of them by saying, hey, look, we don't want anything to do with this, but then who has control?
So this is, so they make an embryo, the wife and the husband, they make an embryo with their own eggs and sperm. That belongs to them, so long as they want to use it for their own child, and they're already protected under existing law to become the parents of that child. The situation we run into is that sometimes people have more embryos than they can use. They already have 3 kids, they don't want more, but they've still got 2 embryos left. They would like to donate them to another family. So they have control over those embryos until they actually make the legal donation to another family. And then that other family gets legal control over the embryos.
Okay.
But sometimes parental status doesn't necessarily go along with that.
Okay.
And so that's what we're trying to fix, is this parental status portion. We want the people who want to be the parents of the child to have the legal rights and responsibilities. And we don't want to keep donors on the hook for something, genetic material that they've donated to somebody else.
Okay, so what happens then when you have that type of a situation and one party says, okay, I'm more than happy, I have 3 kids, I don't want any more, but the other party says no?
So before Dobbs, I would have said that the party that says no wins, and the embryos are going to be discarded. Now, I don't know. That's definitely a gray area. We have not, I don't think there's been any post-Dobbs court decisions in any other state, certainly not in New Hampshire. So we are eagerly watching the law to see how that develops.
So let me ask you, why Dobbs? Is there the assumption that the woman wants the child? Or because you can have a father say, we have 3 children, I don't want any more, but the mother, the wife says, I want those 2. So who makes the decision at that point in time?
So the reason I say Dobbs is because Doe established this right to not procreate. So under Doe, you had the right not to procreate. And courts around the country, not in New Hampshire because it didn't happen here, but courts in other states looked at that Doe right not to procreate and said that almost always is going to trump the rights of the person who wants to procreate.
Doe being another.
I'm sorry, did I say?
Okay.
So Roe v. Wade.
Okay.
Yeah. I apologize.
I know what you're talking about.
But so now Dobbs said Roe v. Wade is gone. So we're on a blank slate with that. And I think that that's important to address, but it's probably beyond the scope of this particular bill.
You know, because that to me brings up a whole nother thing that probably cannot be addressed by this law. But I would think that if you gave your consent to donate your genetic material, that isn't it inherent that you wanted to become a parent? You wanted that child?
So people make embryos and they want one child or they want two. They may not be prepared to take on a third or fourth child, or the couple may get divorced and not want to have any more children with each other. So there's a variety of reasons that people's minds can change. And also people, and I know from my own experience going through IVF, I felt one way about embryos starting out. And then once we went through the process, I was like, oh my God, these are my babies. They're so important to me. So my mind changed through that process. And I've seen it happen with many other people too. So your intent when you start out is not necessarily the same as the intent when.
So to end this here so you can continue on, this particular section is extremely important because it speaks to parental status.
Yes.
And you really need to have this.
Yes.
Okay.
And one or two of these cases a year, so that just wanted to address that issue in the
Senator Whitley has a question. We shouldn't interrupt you. It's just that this is very complicated and we're kind of going section by section and trying to understand. Yeah, and it's, you know exactly what you're talking about. So I'm sitting here trying to understand exactly what this process is and how it works, so that we can at least try to discuss it on the floor of the Senate when the bill comes up for a vote. So, Senator Whitley.
Thank you. And thank you for walking us through this. It's super helpful. I have to say in law school, one of my favorite classes was on this issue. And I'm still learning so much more. So in terms of cleaning up this issue with the embryo donation and parentage, is it also a way to encourage embryo donation rather than destroying the embryo? Or what are your thoughts about that?
I think, when I speak to clients who are thinking about doing embryo donation, if I can reassure them that they're going to be legally protected, that takes away one barrier that might keep them from donating. But of course, it's an individual decision for every couple that every couple has to make based on what they are comfortable with. But, a woman goes through so much. When a woman is going through IVF, she goes through so much. And many women, don't want to see what they went through discarded. Ultimately, they want to be able to have some way to be able to have their embryos used in some manner, even if it's not by the woman herself. If she can give it to another couple, that can be a very positive thing for people who want to participate in that.
Thank you, and thank you for indulging. I know I really appreciate it. Okay, do you want to continue on?
I can.
I think you kind of beat that. No, I think you kind of disrupted her flow. Sorry, because you were just going 1, 2, 3.
No, you're doing great.
Boom.
All right, let me jump down to, I'm on page 3 towards the bottom, legitimacy. So when you have donors, you end up with parents who are not biologically connected to the child. And the problem we have is that all these estate planning lawyers, they like to use this language. They say, we're going to leave, in my will, I'm going to leave everything to my natural and adopted grandchildren. Well, if your natural means biological, and so we've got these children that are neither biological and in some cases not adopted either. So we need to make sure that those children are protected. And the adoption statute came up with a way to protect those children in the adoption context. And what this statute does is it's basically the same language right here to protect these children, the donor conceived children. Next, about the compliance. So reading this section always confused me, and I thought we would reword it to get to what we ultimately meant, which is that we want to have substantial compliance with the statute in order to allow parental status to be established. And we're not trying to nitpick people to make, exact technical compliance. Oops, you didn't check this box, therefore, that's not the mom and that's not the dad. We're not trying to be that picky. We just want people to, substantially comply with the statute. So we rewrote this to just, I think it's more clear for somebody who doesn't work in this field to understand it this way. Next, we have the part about the gestational carrier and her liability. So I want to address this. This is always true in contract law. When you enter into a contract and you breach that contract, you can be held liable in some way. It's never a shall, it's always a can. It's either, do the parties agree on what liability is going to look like, or do we have to take it to a judge and then the judge makes the determination? So there's no mandatory way to hold people accountable in the world of contracts. And so we're just trying to, make that clear in the law. The way the law is currently written, it's putting the cart before the horse. We're getting to how she's going to pay for it, but we haven't even figured out, did she do something wrong? What are the effects of what she did wrong? Was it a material breach? Was it a non-material breach? What are the ways to address this? We got to figure all those things out and possibly even go to court before we get to how is she going to pay for this. So wanted to reword it so just to kind of have an acknowledgement to make it clear that this is a discussion that the gestational carrier needs to be having with her attorney. And this is a discussion that I have with all of my clients about what the consequences are for breach of a gestational carrier contract. So that is what that particular section is. I'm sorry?
You said perfect.
Oh, so I understand that there are some concerns that the language is not strong enough, and maybe we can, work with it and see what we can come up with that is stronger, but still, isn't putting the cart before the horse. Next, so when we pass, and I'll just go back to the breach by the gestational carrier. That's a really ridiculously rare situation. In 13 years, I've never had something like that come up. It's the type of thing when it happens somewhere around the country, the listservs are buzzing because it's just such a rare situation. And let's keep it that way in New Hampshire. Next, so when we passed the 2014 amendments, there was no full service in vitro fertilization clinic in New Hampshire. That meant that we had no laboratory on site that could actually process eggs, form embryos, do embryo transfers, all of that stuff. Well, then that changed, and thank you for passing the fertility insurance bill that led to that change. So now we do have one full service clinic, and hopefully there'll be more opening up. So what, looking at what I've seen in other states, there is definitely a trend where jurisdiction and venue can be based off other parts of the process, like looking at where an embryo transfer took place, where a mental health consultation took place, that kind of thing. So it would be nice if we could offer that as a jurisdiction or venue component here in New Hampshire, now that we do have an IVF clinic in the state. And then let's see, the separation or divorce. So I'll just say that this is already true, like a separation or divorce doesn't affect the contract. Let's just make it crystal clear so anybody who's not a lawyer can, figure that out. In terms of partner, we actually had I will say that I was a proponent of defining partner at the outset. And it is intended to mean a civil union partner. And I know you're gonna say, well, we don't have civil unions in New Hampshire, but we do. We have people from Vermont, New Jersey, and I don't know what other states who have civil unions who have now moved to New Hampshire. So that is something we're going to have. And I wanted to get a definition. I was outvoted by the team, so we don't have a definition in there, but that's certainly something that we could, talk about to clarify what we are talking about, who is and isn't a partner.
Okay, because I wrote down common law marriage. I mean, they're not legally married, but it's recognized that they've formed some sort of partnership. And in just looking at this, we need to define, I think, what a partnership is, what that looks like, because people can form many different forms of a partnership. You could have, two best friends be a partnership. And ultimately, at the end of the day, it's about protection for all parties, especially the children. So I just really think that you folks should really think about how to define what a partnership is.
Absolutely.
but you left. Yeah, you can tell them, guess what?
And then the last thing that's in here, this is also always true, but let's, put it in here just to, it's absolutely crystal clear. So I think that's all I've got. Did I answer all the questions?
I just have a question about the last one here. It seems like it's very strong language that says that, after the gestational carrier is impregnated, it doesn't relieve such intended parent or parents of the intended parents or parents' parental rights or responsibility of the child unless it's determined that the other group did not donate any genetic material. It came from someplace else. What happens though if people are married, whatever, they get divorced and they say, well, we don't want this child anymore. They are now legally responsible for that child. But yet if you go back to the language that I question may be held financially responsible if the gestational carrier violated the contract in some way through their own behavior. I'm not talking about somebody who gets into a car accident and some sort of damage happens, or there's some sort of genetic anomaly that's been passed on to the child. Something that can scientifically be proved that it's something that the gestational carrier did. It just seems that it's not in balance, that you can't say, well, we changed our mind. We decided we want to go on a round the world trip rather than be parents. And then on this hand, the gestational carrier, there's no responsibility. They can be found financially responsible. I think maybe there needs to be a little bit more evening out of this.
So let me clarify. What this is saying is that the intended parents are the parents no matter what. We don't care what happens. We don't care if the intended parents get divorced and hate each other. Too bad. It's your child. Go to family court and, figure out your custody between yourselves. It's your child no matter what. The only exception is if the gestational carrier accidentally got pregnant with her own child. So if the gestational carrier and her husband had intercourse when they weren't supposed to and got pregnant with their own child, that's the only exception at all. Otherwise, it is 100% their child. And even if the gestational carrier drank a six-pack every day of pregnancy and the child has fetal alcohol syndrome, which, doesn't happen, but even if hypothetically that happened, it would still be their child. They're still taking the child. The gestational carrier may have some financial responsibility to reimburse them, but she doesn't keep the child because of that.
Okay. I got a lot of questions, but it is kind of late in the day and everyone's, it's just, this is really interesting. And to me, it's fraught with a lot of issues. And I'm thinking back, my God, when, 1970s, 1980s, when these things were happening and people were suing each other back and forth. And, a child was born with some sort of anomaly and the parents didn't want it. And so what happens to this child now? So you're saying it belongs to the parents no matter what. And so the parents can say, hey, we don't want this kid, we're putting it up for adoption. It just seems like, it just seems like there's issues.
We don't really see that happening because this is an incredibly complicated process to have a child through surrogacy. It's really hard to do and it's really expensive. We're talking $150,000 or more to do this. So, and the intended parents under the existing statute have to have a mental health consultation to make sure that, they're in the right frame of mind to understand that this is their baby no matter what. So I'm happy to meet with any individual senators to answer any additional questions and, talk through more of this.
Thank you. I appreciate your time this afternoon. Your answers have been very, very helpful, at least for me anyway, to try to get my head around this process. I remember the original bill. I think I was a co-sponsor of it back in 2014. So I know that this is very important, and I think I actually co-sponsored the insurance bill as well, and that it is something that is greatly needed for our constituents here in New Hampshire. I just want to make sure we get it right.
Yes,
And there are no
absolutely.
unintended consequences that would
Absolutely.
prevent people into entering into these agreements, as well as for people becoming parents.
Thank you.
So are there any further questions?
Just one.
Senator Whitley?
Yeah, thank you, Madam Chair. You mentioned, maybe I missed this, I apologize. You mentioned you had been working with a group to come up with this language. Is it a group of other attorneys or who have you been working with?
Primarily attorneys and the senator, and some folks from GLAD, one of whom is here today.
They're here.
A couple other attorneys.
Attorneys that follow?
Yes, follow up.
Attorneys that work in this area?
Yes.
Okay, thanks.
Okay, great. Any further questions? Senator Abbas?
Thank you, Madam Chair, and thank you for taking my question. And I understood your testimony that there are some people who, without a legal background, get confused when they look at the law to see if they're eligible to be a gestational carrier. If I'm looking at page 4, lines 13 through 26, if I read 13 through 16, it mentions, a gestational carrier, a woman intending to be a gestational carrier. Then it goes on to list, and I understand, I'm not trying to have the pronoun debate today, where it says, it changes to they, but the most common use for they would mean 2 or more people. So when it says they and their spouse or partner, I understand what the intent of that means based on the testimony of the senator who introduced the bill. But is there any concern that members of the public would not understand? Because they and their spouse or partner, like, who's the other person?
So those theys were not in the original draft. They were put in by legislative services, so I think, it sounds like that's what, legislative services wanted to see.
It says, and just a follow-up,
Yes,
Madam Chair,
follow-up.
it says they completed a physical medical evaluation. They completed a mental health consultation. And I understand what the intent from what the sponsor of the bill said, but at the same time, do you think members, again, I think that same confusion could become out of the public.
I think it's important to have gender neutral language in the laws. This whole entire statute is already actually gender neutral according to a court case, the Madeline M. court case. So, changing this language doesn't change the effect of the law. It just brings the terminology up to being gender neutral itself.
And one last thought, could it say she or they, or and or, I mean, I'm just saying, because you get what I'm saying, that there is some confusion where
Yeah.
people may read that incorrectly.
Senator, would it be okay if I took some time to think about that question and get back to you with the best answer?
Yes, thank you.
Are there any further questions? Okay.
Just
Senator
amuse me a little
Gannon.
more. I'm not as much Archie Bunker as you think. Again, if you could just, gestational carriers, only the carrier part, those terms only used in a few places too. It's only a few. If you had woman, that's all, the only one who can carry a child is a woman. So why can't I, because of your gender neutral case, I can't have woman on line 9? Or, yeah, line 9.
You can
Gestational
have,
carrier means a woman. That just
you
makes
can
so
have
many
woman.
people.
You can have woman. It's just going to mean woman or man.
We scratch out and have person. On line 9, I've scratched out woman, like all over the place. Woman is fine and it's person. Can I not have the word woman? Because of your gender neutral things?
I
know the
completely
intent.
understand.
This is like a total small little issue to you.
I
And it's not
understand.
the intent of the bill, and I have no problem with what Perkins Cocoa wants here. I'm fine with all that. It's just, it's a woman is the only one who can carry, so put woman, because that is correct biologically, it's correct grammatically, it's the way to do it. So
So-
it's like 2 times that I need that.
I hesitate to answer only because I was working as part of a team
Sure.
of other attorneys, and I don't want to give an answer on behalf of the team and not be correct.
There's
in
other
terms of the team's
places you
intention.
use gestational carrier that are fine because they mean something else, but there's a couple places where it's only intended and only could be a female. There's like 2 or 3 places. That's all I would care about to change. And then you'd have a much easier sale on the whole bill.
Can I take that back to the team and,
Sure.
and have a discussion, and can we get back to you? And I think that the
Because I
next,
think the bill is great. I know what you're trying to do, but
I think
just
the
a
next
little bit.
speaker may have some,
Oh, I thought we
maybe
were
will
done.
address that issue better than me, actually.
Thank you.
Yes, Sure.
I'm sorry, I have a question about page 5, section 12 of the bill. And it says that if there's a breach of the provisions of the chapter, the gestational carrier agreement, or if there is harm or a breach causes harm to a resulting child, the gestational carrier may be held financially responsible for such harm, right? And my question is, by whom?
By a court. It's either going to be agreement by the parties or held responsible by a court, unless the parties have agreed to arbitration, binding arbitration, in which case it's going to be by the arbitrator.
Typically, if there's harm caused to a resultant child, it's the child that has a tort claim?
This is a contract claim?
Well, but you're talking about harm. I mean, you're talking about what appears to be bodily harm caused by a breach, so that would potentially be a tort claim as well.
And I
Maybe I'm wrong, but
I don't think that that is precluded by this. I think that this just addresses purely the contract claim that the intended parents have. And then whatever claims the child has would be separate from this.
it raises an interesting question to me because it makes a living person the subject of a contract claim, like piece of chattel, which is typically not how we do things.
You know, I think that there are other examples, though, where contract claims come in with.
This whole thing raises really interesting legal questions. I'm interested you can make it your whole legal practice, too. I mean, I think that's great. I'm glad it's happening, but it raises hard questions.
Yes. Senator Abbas?
Just to clarify, so the parents, getting into the pronouns here, that they would have a contract claim, but the child could have a tort claim?
Mm-hmm.
Is that? Thank you.
Mm-hmm.
That might be something to take back to the working group and get their opinion that there might need to be a separate section that would give the child status in this process as well.
That's an excellent idea.
Okay, see, we do get some good ideas every once in a while. Okay, does anyone have any further questions? Okay, seeing none, thank you very much. You have been extremely generous with your time.
Thank you.
I appreciate it. Okay, next we're going to call Chris Urchel. Good afternoon, Attorney Urchel. Watch the wire, please, don't trip.
You happen to know I'm going to be very brief.
Take what you need. Yeah, please don't worry about it, because whenever anyone says I'm going to be really brief, very rarely are they. So that's okay. You take all the time you need.
Thank you, Chair Carson. I'm Chris Urchel. I'm an attorney with GLBTQ Legal Advocates and Defenders. I'm a New Hampshire licensed attorney, but I work mostly in Boston, or I'm based in Boston. I do represent a lot of people in New Hampshire. Unfortunately, I have very little content area expertise. Our director of family law could not be here today. As Attorney Tucker explained, we've been working in coalition, GLAD, Resolve New England, Fertility Within Reach. Attorney Tucker and other individual practitioners who work in this area every day have been working on this bill for some time, along with Senator Perkins Quokka. And I just want to make it clear that GLAD stands behind this legislation. I also want to address the issue that I do think that inclusive language is really important, as Senator Perkins Quokka said. I also understand that Senator Gannon, what he characterized as a woke language can be inflammatory for some people. I think it's reductive to characterize it as being on either of those two categories alone. When we're talking about statutory language, precision is really important, as we all know. And, as a person who represents almost all my clients are transgender people, which means that, a transgender woman is somebody who is born male, but identifies as a woman, and a transgender male is someone who was born with a woman's anatomy, but identifies as male and uses he, him pronouns, and might have legal documentation identifying him as a man. And while as of today, I'm not aware of any examples of a transgender man being a gestational carrier for anybody, I think it would be ridiculous to assume that's never going to happen, considering the changes that we've seen in the last decade in terms of, transgender visibility and also advances in, medical care and everything else that have made it possible for transgender people to participate in society in myriad different ways that they never have before. So, given that it is almost inevitable that there will be a transgender man serving as a gestational carrier in New Hampshire, I think it would be silly to, make sure that the law precludes acknowledging that person as a gestational carrier. And I just want to add one more thing, which is that we're under a lot of pressure, not just from one side, but from both sides to talk about language with precision. In the Dobbs decision that Justice Alito penned, he specifically made a point about how pregnancy is not a women's issue because there was an equal protection claim brought in that case. And he said pregnancy is not a women's issue, it's a pregnant person issue. And that was his ruling on equal protection. So we're under pressure, immense pressure, to be very specific in the language that we use. And I think it was important that this bill reflects that. To the point about confusion, I think that, you're absolutely right. But whenever there's a they or a there, you can use the term gestational carrier or child in place of that, and it'll accomplish the same thing. And I would not be opposed to any amendments to that effect.
Thank you very much for your testimony, Mr.
Thank you.
Urkel. Are there any questions?
Thank you.
Thank you very much for sticking with us this afternoon. Okay, are there any other members of the public that would like to speak to Senate Bill 264? Okay, seeing none, we will go ahead and close the public hearing, and we are done for today. Thank you all for being here. We really appreciate that, and we look forward to working with you to resolve any issues.